May it please the lordship, my lord. My lord, seeking the lordship in adjournments, my lord, in respect of item 31 and 32. These are analogous matter. I have got the consent of other side, my lord. I have some personal difficulty. Maybe taken next week, my lord.
31 and 32.
32, my lord. Next week, followed by
32, my lord. Petitioner, my lord.
Acha. We'll have it after 2 weeks. After 2 weeks. At 31 and 32, on the request of Mr. M.H. Raj Borgia, Learned Counsel, made with the consent of the counsel for the opposite party. Both admission hearing of these two writ petitions stand adjourned for 10 days. Registry to release these matters again after 2 weeks as fixed items.
Obliged.
May it please the lordship, I beg to mention item 39, madam.
Yes.
But in this matter, madam, we are required to file our response, madam. I propose 4 weeks' time, madam. I have taken the consent of other side.
With the consent of learned counsel for the writ petitioner, comma, Mr. M.R. Adhikari, learned CGC, prays for and is granted
4 weeks' time.
4 weeks' time to file counter affidavit.
My lord,
The
in
matter-
this regard, there's interim may be extended.
Let the matter be listed after 4 weeks, interim order passed earlier to continue.
Oh,
May I please mention for listing, my lord.
When you want,
Matter is for age relaxation in EPC. Actually, the petitioner number is already selected for the post of junior engineer. But his case is withholding due to pending disposal of this case, my lord.
when you want it, when,
Friday, my lord.
next week,
Monday.
next week.
May I please, your lordship. My lord, I beg to mention item number 51, my lord.
Hmm.
Kindly pass over for the day.
Item 51,
51, my lord.
you are for the petitioner.
Petitioner, my lord.
Your name, please.
A. Burman.
On the request of Mr. A. Burman, learned counsel for the petitioner. Hearing of this matter stands adjourned for 2 weeks, list accordingly. Yes.
Obliged, lordship.
My lord, I beg to mention for listing, my lord, contempt petition. A petitioner will retire from service on 31st of this month, my lord.
Next
Kindly
week, next week,
listen
next
tomorrow, my lord.
next week.
May I please, lordship, I beg to mention item number 40.
Hmm.
We would like to file an additional affidavit, kindly adjourn it for the day.
You are appearing for whom?
Petitioner, my lord,
Miss
T. Wapangla.
T. Wapangla, learned counsel for the writ petitioner, submits that the petitioner wants to file an additional affidavit in this case so as to bring certain facts on record, and therefore she be granted, how much time?
Next week,
2 weeks' time to do the needful. Since the prayer is not opposed, same stands allowed. Let this matter be listed again after the additional affidavit is brought on
Obliged.
record.
May I please, your lordship. Lordship, I beg to mention for listing of a writ petition next week for admission column. Much obliged.
Please, your lordship. Lordship, I pray for listing of a matter, lordship, regarding non-payment of pension, stoppage of pension. So, lordship, matter may kindly be taken on Friday. For last 6 months, they have.
Next week.
Next week, lord.
My pleasure, lordship.
Obliged.
I beg to mention for listing of a transfer matter, lordship, WBC. Can it be fixed on 1st of August, lordship? Lordship, there is another, it's a service matter, lordship. Can it be fixed on 5th of August, lordship? Obliged, lordship.
Lordship, with the consent of the petitioner side, Lordship, I beg to mention item number 18, Lordship. This
Yes.
matter will be taken after 2 weeks, Lordship.
On the request of Mr. S. Sutradhar, learned counsel for the respondent numbers 1 to 4, made with the consent of the opposite party. This matter stands adjourned for 2 weeks. List accordingly. Item 18. Item 18. is
Yes,
it?
Lordship. Obliged, Lordship.
May I please, your lordship, I beg to mention item number 17. Kindly matter may be passed over for the day.
You are for whom?
I'm for the petitioner, lordship.
On the prayer of Miss
R. Shaheen.
R.
Shaheen.
Shahin and counsel appearing on behalf of the writ petitioner.
Kindly matter may be fixed on the next
Admission
week.
hearing of this matter stands adjourned for 2 weeks. This case again after 2 weeks.
May I please, lordship? Lordship, with the consent of the other party, I beg to mention daily list item 24.
Item 24 years. What do you want?
Lordship, can it be adjourned for the day, for a week?
You are for the petitioner,
Respondent,
respondent,
lordship.
the corporation department.
Yes, lordship.
You have informed the other side?
Yes, consent is taken.
You have informed whom?
Mr. B. Sinha.
With the consent of learned counsel for the petitioner, the learned standing counsel corporation department, Assam, has sought adjournment of admission hearing of this case with a request to post the matter again after 2 weeks. Prayer allowed, let the matter be listed accordingly.
Obliged.
May it please Mr. Lordship, my lord. My lord, to read petition, my lord. I'm praying for listing on next week. Obliged.
My pleasure, Lord. My lord, I beg to mention item number 36. Last week, my lord, the government filed their counter affidavit in the matter. We need 10 days time to file our reply.
Item number
36. We have for a petition.
Mr. J. Patwari, Learned Counsel, appearing for the lead petitioner. Praise for it is granted 10 days time to file rejoinder in respect of the affidavit filed
By
by
the government.
government of Assam. Prayer allowed,
Deeply,
and list the matter accordingly.
deeply.
May I please, your lordship? I beg to mention for listing of a matter, transfer in this pension matter. Can it be on Friday?
No,
If possible, next week, ma'am. Next week.
next Friday.
Okay, thank you.
May I please, your lordship? May I please, your lordship? Lordship, I beg to mention for listing of writ petition for orders next week.
May I please, your lordship? Lordship, I want to mention regarding listing of a matter on Wednesday, lordship.
What is the matter?
Matter is regarding pensionary benefit of the defense personnel. He retired in the year 2016 and since then he is not getting his pension. Much obliged.
May I please, your lordship, I beg to mention item number 46. My lord, my senior is not present due to his illness, my lord. So
Item
I'm
number?
praying for some accommodation.
Item
Item number
number?
46. We are for the respondent and I could not take consent from the petitioner, my lord.
You wait, when the matter is called up, then we'll pass it on.
Okay.
You remain present, otherwise we'll give personal appearance. Yes.
May it please, lordship.
Hmm.
The petitioner herein is being aggrieved for non-compliance of the order dated 27/7/2023.
Hmm.
And despite blessing representation on 2 occasions, the respondent failed to comply with the honorable court order. The relevant portion of the order is page 13, annexure 1, para 8 and 9.
All right. Pardon, miss, your name please?
Tiwa Pangla.
T. Wapangal and a counsel appearing for the writ petitioner. Alleging willful disobedience of the directions contained in the order dated 27/7/2023 passed by this court in WPC number 6896/2010. The instant content case has been filed. I have perused the statements made in the petition. Stop issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the 6 weeks post up. At this stage, this court is inclined to issue notice only upon the respond number 2. Petitioner to therefore take steps for service of notice upon respond number 2 by registered post with AD. Question of issuance of respond notice upon the respond number 1 shall be considered at an appropriate stage as and when the occasion arises.
May it please, your lordship. Look, this is a matter pertaining to departmental proceeding. On the last.
What is the
occasion-
instruction?
Yes, lordship, it has been forwarded, lordship.
So notices to go, notices to go in this matter, my lord. This is a matter pertaining to departmental proceeding. Honorable Court wanted to confirm whether the appeal has been received by the authorities or not.
Received and forwarded, lordship.
Take down. Mr. H.K. Das, counsel for the petitioner, aggrieved by the order dated
17/1/24. 894.
17/1/2024,
24.
inflicting the penalty of within stoppage of 2 increment with cumulative effect unquote upon the petitioner. He had failed, he had
Dismissal from service, my lord.
No, sorry, dismissal from service. Minor noise, major penalty of dismissal from service. The petitioner had referred an appeal for the competent authority. However, when the appeal was not entertained and oblique or proceeded In accordance with law, the petitioner has approached this court by filing the instant writ petition. Stop. Taking note of the grievance of the petitioner, this court had passed order dated 27/6/2026, requiring the learned government advocate Assam to obtain instruction as to whether the appeal preferred by the petitioner has been forwarded to the Commissioner and Secretary to the Government of Assam, Home and Political Department. That is the competent authority to decide the appeal, for disposal of the same. Stop. Today, when the matter is called up, Ms. M. Bhattacharjee, learned additional senior government advocate Assam, has produced a copy of the communication dated 4/7/2024, which goes to show that the appeal preferred by the petitioner has recently been forwarded to the competent authority for a decision of the same on merit. We'll dispose it off with liberty. We'll give them 2 months, 60 days time to.
No, let them decide the appeal pending consideration.
No,
Milord,
then
because-
the appeal will be stayed. Both can't happen.
Sorry, Milord.
You can't rewrite the law. If you want the appeal to be decided, then we can lay down some guidelines and ask them to decide.
Milord,
the
my
appeal.
basic challenge is the penalty order, Milord. I have submitted appeal during time, Milord. They have kept it pending, Milord.
However, at this stage, Mr. Das submits that instead of pursuing
Because
the
I have
appeal,
only 1.5.
both cannot go on, Mr. Das. Don't waste the court's time. You cannot ask for anything and everything you want. Should the appeal proceed or should you want the matter to be decided on?
Matter to be decided on marriage.
All right. Mr. Das at this stage submits that his client is waiving his right to prefer the appeal and would request the court to decide the writ petition on merit. Full stop. In view of the above, the respondent authorities need not proceed with the appeal any further. The the consequences, if any, in respect thereof, would ensue in this proceeding at this stage of hearing. Full stop. Issue notice returnable in 6 weeks. Since Ms. M. Bhattacharjee, learned government advocate Assam, has appeared and accepted notice on behalf of the respondent numbers 1 to 4. No formal notice.
All the respondents.
No formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental council within a week from today, so as to enable her to obtain instruction, file affidavit, list the matter accordingly. Mr. Das, you can't say that, let them proceed with the appeal. So your writ petition will be in trouble.
Milord, he has only 1 year service left, Milord.
Whatever, we could have asked them to decide it in 30 days. That would have been very advantageous for your client. I don't understand why the councils start behaving like the clients.
No,
This is very sad.
that is the
Yeah, any factual dispute, your writ petition will be dismissed. And you will be responsible for that. You could have asked them to decide the appeal in 30 days and communicate an order. Now, if there is any factual contention, the court will say, we're not going to it. All right, next matter.
in that event, my lord will.
No, will not change.
Fine,
Yes,
much over.
yes.
Well, may it please your lordship. The petitioner before your lordship was the branch manager in the dispute branch of the Apex Bank. Well, at certain transactions, he's approved at the instructions and the approval of the managing director. This is called discounted bill purchasing. It's an old method of doing business at the bank, but it was not discontinued. It is the approval, he did it, and earlier also he did, and the monies were recovered. Now, subsequent to this particular 2 or 3 transactions, some news items were published and broadcast in TV channel. Then the departments came heavily upon me and said that these are all malfunctionings and these are my corruptions.
Mr. Chamua, the reason sometimes as a judge I react is because as a lawyer, you think what is legally the best course for your client. Right? We'll issue rule and hear this matter in due course. Is that what you want?
No.
Then what do you want?
My limited prayer today is, my lord, that let the inquiry go on. I will face the inquiry. But the very fundamental foundation of the entire inquiry, where the managing director himself is the center figure of whole disputes, and he become being my disciplinary authority issued the charge and everything, appointed the inquiry officer, and the inquiry officer was appointed with whom I have some personal enmity. Everybody knows it. I raised those questions. Sufficient documents that I would like to rely upon were not provided to me, and the inquiry is going on. Only on this point, limited prayers, though I have stated all the facts, my lord, for the purpose that I am not suppressing any material things. I have annexed everything, so it looks maybe little heavier. But the only thing that, my lord, that let me have all the documents first. I will reply to the show cause. Let me have that opportunity. I'm not denying to face the trial. I'll face it. But how can a person who is the center figure of the dispute, being the person, be okay, he may be the disciplinary authority, but he should disassociate himself because.
Which are the documents you want? Which are the documents? Where is the list? Is it mentioned in the body of the writ petition?
My lord, I'm annexing those documents where I have written to them, my lord, that these are the documents they should provide me.
Where are those? Where is the list?
My lord, at page 85, annexer 17, paragraph 3.
So, Mr. Goswami, have you given these documents to him?
Yes, my lord.
Huh?
We have not given these documents, my lord, because we are saying that these are not with the head office, it was with the branch office. He himself has annexed these documents, my lord. But he has already in receipt of these documents, my lord.
That will not do. You have to furnish from your side.
Okay, we'll furnish him. He is asking for 3 documents, my lord. One is not yet ready, that is the audit and inspection report, it is not
Wait a
ready.
minute. One is?
One is, my lord, page 85, para 3. One is, my lord, letter of Mr. Rajesh Bajaj, Director, MS so-and-so, requesting for allowing the DBPs. Then second is fact-finding report pertaining to DBPs under question containing the inferences drawn by the inquiry officer. If my lord peruses, and the third one, my lord, is not available because this inspection is not yet complete, my lord. The inspection and audit report. It is ongoing, or it will take some time, my lord. We are not having this.
So are you going to rely on this third document?
No, my lord.
Huh?
What we will be relying, my lord, we have already given a list of documents. Those documents have been furnished to him. He wants, my lord, certain documents to be a document for in the prosecution side. That he cannot. He has to bring it as his defense evidence, my lord.
You can only ask for documents which they will rely, not the ones which they will not.
Anyway, my lord, if he is asking for these documents, my lord, first 1 and 2, if my lord peruses annexer 1, my lord, and annexer 10.
Yes.
These are the documents he has already annexed, my lord. We are not disputing the correctness. So he may not be required to give an original copy, my lord. It is already with him, my lord. Page 31, annexer 1 is the letter he is asking for. And annexer 10 is the second letter. That is the inspection, internal inspection, internal inquiry. He's already having all those documents.
My lord, no, my lord, kindly come to page 91, paragraph 3. I have written 1,000 times, my lord, that these are the things.
All right, let the inquiry go on. We'll hear the writ petition in usual course.
My lord, difficulty is there.
This will prejudice my cause, my lord.
No, it will not prejudice his cause.
You are not being able to tell the court what exactly is your problem.
Two problems. The documents that I am relying upon, or they have not yet provided the list of documents and the list of witness. My lord will see. I'd like to.
What is the stage of the inquiry?
He is not appearing before the inquiry officer. Yesterday, he wrote a letter to the bank that since I have filed a case, until a high court pronounces a judgment, I will not be appearing. Well, tomorrow, this date is fixed today. It was fixed yesterday, my lord.
No.
So he himself has passed an interim order in his favor. This was the letter, my lord, submitted yesterday, last paragraph, my lord.
No, date is fixed today, my lord. 24/7 at 11 AM. My lord.
Mr. Chamua, court proceedings are not meant to go for arm testing with the authorities. Here in the courts, we will only see if there is a violation of somebody's right. The inquiry proceeding is going on. You must appear there.
My lord, I have not yet submitted I have not been able to submit my so-called reply even.
Why?
They have not provided me the documents. For effective reply, it is necessary, my lord.
No,
Let me have my defense, my lord. Well, I'm not going away anywhere.
No. you have, you can only ask for those documents which are referred to or.
My lord, if my landed friend can show one document, my lord, that whether they have submitted a list of related documents and a list of witnesses in the proceeding. Let him show me.
All right, Mr. Somasi, the point is, you want those documents which are not included in the list of
My
documents.
lord, they do not have even a list of documents. Let him show that this is the list of documents annexed in the, along with the search sheet.
So you appear before the inquiry officer and ask for the list.
Page 69 is the list, man. He himself has annexed, man. Page 69. 64 is the so cause notice, 69, my lord. Statement of allegation and list of documents, man.
So these
No, no.
documents are what? Part of the,
Part of the so cause, my lord. Along with the so cause, we have furnished these documents, my lord. Then he wrote a letter to the bank. I am not getting the, I have not received it. That is what his contention. Again, we have sent it, my lord. Page 82, man. Page 82, annexure 16. To his reply, my lord, reference, my lord, may see, he wrote a letter on 21/11 that he has not received.
My lord,
Page 82.
yes.
page 82, my lord, second paragraph from the bottom.
Hmm.
In matter of list of witness, we inform you that as and when the inquiry process to the aforesaid deputed so and so will start.
List of witness, you can't get it. They have not decided to draw departmental
Yes,
proceeding
yes.
against you till now. That's what I am hinting at. There appears to be a total misunderstanding of the law. Now, have you initiated departmental proceeding?
Now, my lord, inquiry officer has been. appointed.
Memo charge has been, charge memo has been
Yes.
served,
Yes,
right?
yes.
So,
We'll give him
initially,
a, whenever he.
just a minute. Initially, there was a show cause. He replied to that.
No, I
He could
have
not,
not.
he did not reply because of these two documents, well, he's asking for, my lord,
Hmm.
which he already have annexed.
Then due to failure on his part to
We
reply.
appointed inquiry officer, my lord. Inquiry officer has now summoned him, he is not appearing.
And we have an allegation that this inquiry officer, there are probability of bias because I have personal enmity with this person, except this man, anybody, my lord. My prayer are innocuous, my lord. I am not saying that don't do the.
So, what do you say about this? Otherwise, we'll have to decide this, then it will take time.
Only difficulty, my lord, there are three officers above him, my lord. One has caused that in internal inquiry. So we are keeping him aside, my lord. And the rest, there are rest two. One we have appointed. Now he is alleging biasness, animosity against that person without any material.
But at
But
person
if
at
need,
par.
we can definitely change the inquiry officer instead of.
So, you see, otherwise, this aspect we'll have to examine.
Exactly.
Then this proceeding will be stalled.
But, my lord,
So why don't you?
we'll change the inquiry officer, my lord.
Huh?
Bank was of the opinion, my lord, I have given an instruction received yesterday, my lord. Bank was of the opinion that inquiry officer is to be an officer above his level.
Yes,
It's not required. Inquiry officer can be of at par, my lord.
Yes.
He's not a disciplinary authority, he's an inquiry officer. So there will be, should be other officers, my lord. We can change the inquiry officer.
After tomorrow, we'll have it
My
for
lord.
motion
My
again.
lord. And we'll give the documents also.
And also these documents.
Yes,
Yes,
yes.
You hand it over in the court.
Yes. Whatever is available, my lord, we'll give.
Because
Because
the only thing, only prayer, then in that case, my lord, the only prayer, limited prayer would be, my lord, that I may be allowed to reply to the so cause notice. Maybe, okay,
Reply means.
to the so cause, because so cause notice.
That can't be done. They've initiated the proceeding.
But that,
Sorry, that cannot be done. Show me a judgment which permits it.
but I'm not saying that lordship should set.
No,
set back the clock.
you should have reserved your right to make additional reply, but you should have made a response. You missed the bus. Now, after the proceedings have been initiated, now you can't say that, let me tell them that there is no need to draw a proceeding.
But I will respond to this, my lord.
You do, but then day after tomorrow.
Yeah,
if they give
all right,
the
my lord, after
documents
tomorrow, let my friend come with an instructions. I will also
And-
take instruction on this.
And if they change the inquiry officer,
we'll change, no problem.
we'll close the matter.
My lord.
That prayer you cannot make. Even if you don't have one or two documents, you should have said that I'm reserving my right to give further reply. I'm handicapped because of this, but I'm denying the charges. What prevented you from doing that?
Maybe one way of being, one way.
That's
of
the only
course.
way of doing it. You cannot ignore the writ of the disciplinary authority in this manner. Oh, I don't feel like replying, I will not reply. Consequences will ensue. Now the consequences it has already moved on. They have initiated departmental proceeding. You have to face the departmental proceeding now. There's no doubt.
That I'm not denying even. I say, I pray, my
You
lord.
just
for the-
denied. You just wanted to reply to the initial show cause. Initial show cause is for considering whether a DP should be drawn on.
Yes.
My lord.
The initial show cause stage is over now. DP has been drawn.
Yes.
So why do you want to file a show cause against the initial notice? Mr.
Well,
Chumwa,
let my friend come up on the
Mr.
next.
Chumwa, there should be clarity of understanding of law. Is it not?
Well,
What order comes, what submission is made, that's another thing. But when we are professionals are dealing with matters, there should be clear understanding of how the law.
because the other, that is a gray area.
Mr. A.C. Chumwa and the counsel, A. Chumwa and counsel for the petitioner also heard Mr. P. N. Goswami, and standing counsel, Assam Cooperative Apex Bank Limited, who seeks posting of this matter again on day after tomorrow, date to the.
Monday,
To take instruction as to change of the inquiry officer and the providing documents.
Monday.
To obtain instruction on the two points raised by the petitioner's counsel, namely change of the inquiry officer and also for providing the documents,
Whichever available with the bank.
providing the available documents sought for by the petitioner, if the same are available with the bank. List this case for motion again on.
Wednesday next month.
Yes.
Wednesday.
Wednesday next.
Wednesday.
Wednesday next, Friday or Wednesday. Pendency of this writ petition would not be a bar for the bank to proceed with the matter in the light of the above. Motion. Mr. Chomo, come up with cases which becomes so impeccable that the judge is bound to give you the order. You are asking for things which are completely not tenable. Apply your mind and see what is the relief you can get. You can't just ask for things and expect the court to give it. You are asking for things which are not permissible.
But
That is
providing,
the
not,
job of a
but at the same time, I have
What
some
you are asking
authorities.
for, your client could have been here and asked the same thing.
No, my lord, this is, I appreciate to this, my lord, but I have some judgments in my hands. Had the hearing taken place, I would have relied upon.
Yes, what is the point on that?
That the non-furnishing of documents vitiates the whole inquiry. Yes.
They are furnishing you the document.
But when they are furnishing while I approach this court.
The inquiry, the
Not-
inquiry is not.
Fairness, law is not a one-way traffic to my humble understanding, my lord. Law is for them, law is for me too.
Mr. Goswami, please sit down. Yes, argue on the law. I want to know what is the law.
Not on this, my lord. What I'm saying, I was repeatedly asking for certain documents.
Mr. Chumwa, I am asking you one question. When you got the show cause notice,
Yeah,
you
that part.
have always said that I am
Yes, yes,
handicapped.
that part I agree. with.
I am
I
denying the
already said
allegation.
that part I agree.
Have you denied the allegation?
No.
Then-
That part I agree, my lord. And that is why perhaps I prayed before this court that I may be allowed to do this.
Yes. So I am saying the law is such that the clock cannot be set back.
I
The
understand.
departmental proceeding will now have to go on unless it is set aside on any of the tenable grounds. Do you agree with that? If you don't, you are free to argue. You are asking that give me the documents, I will file reply to the initial show cause and then let everything go.
Well, sometimes the client does some works without the guidance. That is why it
You
may.
are the client for us.
It may
Don't
happen.
blame the client. like this. No, anyway, there is nothing personal here.
No, I understand. And these are the course that we learned from the court also.
What I am emphasizing on is we should raise the level of legal discourse to the next level.
Man,
When you are coming to the court,
I'll do that.
try to anticipate what are the legal issues, what are the questions coming from the court, how will you answer? That is how this bar will go up,
Man,
standard will go
we
up.
appreciate it.
That's the reason why I get into this
Yes,
interaction.
I bow down to this man and always. And
Otherwise, there is no need. I can just silently listen and pass my own orders. But the reason why I get in the morning, a little while back, I asked Mr. Das, what is the course he wants to. So he should have been prepared with this query, an answer to this query. This is the work of a counsel. You have to anticipate what are the questions that may come and be ready with the answer. So that when the judge is asking, you can lead the judge to the answer that suits your client, but it should be within the confines of law. That doesn't happen. That is not happening in my court. I don't see people doing it. Just come and say, I want this, I want this, I want. What is the point in saying I want? Merely because you want, the court is not going to give you. You have to figure out what is your strength, what is your weakness, how much you can get under the law, what is the obstacle, what is the best course available, course number 1, course number 2, course number. And during the course of interaction, tell the judge that this is what you are seeking. So I am saying this because you asked for something which was good enough to completely lose interest in your matter. You wanted documents to submit reply to the initial show cause. That is completely untenable. So when you ask something which is completely untenable, the judge becomes negative. You should not do it as a counsel. That's what I'm saying. Don't ask for something that is totally impossible, and then the judge becomes negative, and then it affects the prospect of your client. These are some lessons of advocacy which we had learned in our initial days. Don't mind me for
No,
saying
no, my lord.
I mean well for you and the learned members.
Of
the-
course, my lord. Of course.
Therefore, I'm saying this. And that way, our level of debate, discussion, quality of judgments, these will all improve. Slowly, slowly, Guwahati High Court orders will get a much bigger respect in the Indian judicial system. So all of us have to work together for this. It's not just I come with something, just tell the judge and I get it, fine, I don't get it. That's not the point of this system. The point of having this system is to further the cause of justice, not to further the cause of an individual litigant. That's the point. Anyway, you consider
You are
what I
blessed,
said
you are blessed to this.
and see if it is helpful, then see how you can use it. Otherwise, ignore it. All right, next matter, please.
Obliged. Obliged.
Item 4.
Yes, none appears to the petitioner and matter stands past. You're there in this case? Star and thus learned standing counsel,
Water resource.
water resources. Department.
Water resource.
Some is present. Let the matter be listed again in the next one.
Item 5.
May I please look at this is regarding non-release of the retirement benefit.
43,924 not yet paid.
Lordship,
Why?
instruction is required, Lordship. Let them file an affidavit, my lord.
Will issue notice then.
No, Lordship.
Third, Mr. S. Boral and counsel for the petitioner. The writ petitioner hearing has retired from service on 29 to 2024 in the post of construction engineer under the Assam State Housing Board. The grievance of the petitioner is that the respondents have failed to pay the amount of rupees 18,43,924 as the retirement benefit even payable to the petitioner till today. Mr.
T.R. Gogoi, Lordship.
C.R. Bugui, Learned Standing Council,
Assam State Housing
Board, raised for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Gogoi has appeared and accepted notice for all the respondents, no formal notice extra. Respondents to bring their stand on record by filing a bill.
Lordship, fix it.
6 weeks.
Lordship. Okay.
Item 6. May I please, Lordship? Engaged counsel is on leg, Lordship. Matter may be taken after some time.
What is this matter about?
My lord, I have I have no brief.
Who's the engaged counsel?
M.I. Hussain.
Call him next round, we'll take up.
Okay.
Pass for the time being.
Item 7, my lord, I apologize. We have challenged Annexer 7,
Hmm.
but then Annexer 7 actually has flowed from Annexer 6. So some correction in the petition would be required. So I
want to
would beg
rectify?
to withdraw. my lord.
Mr. The Pathak, counsel for the petitioner, submit that there is some defect in constitution of the writ petition which calls for rectification. As such, the learned counsel has paid for leave to withdraw this writ petition with liberty to file afresh after rectifying the defect. Is B. Sharma, learned CBC, appearing for the respondents, does not have any objection to the prayer. In view of the this writ petition, then disposed upon withdrawal with liberty.
Deeply obliged.
Item 8.
The petitioners are seeking pay parity. They are civil defense violence demonstrators. Now they are seeking pay parity with that pay scale of home guards, which have been declared in the earlier pay revisions.
The read petitioners hearing are seeking pay parity with the home guards engaged by the government of Assam. Had Mr. P. Bharadwaj, learned counsel for the petitioner, there is the amendments made in the read petition. NOM 8 weeks since Mr. C.K.S. Borua, learned government advocate Assam, has appeared and accepted notice.
145, Lord.
For respond numbers 1,
145.
2, and 5.
Finance, sir.
And Mr. 1, 4, and 5.
8.
Mr. H. Earlier for responding by 2 and 3.
66.
And, 2 and 3, Mr. Chalia, is it? And who's the accountant general? And Mr. Huh? Who's the standing counsel for the accountant general?
Mr. Architect.
And Mr. Architect, standing counsel, AG Assam for the respond number 6. The service of notice is deemed to be complete in this case. The respondents to file affidavit responding to the government's mailing the petition on or before the returnable date. This is the matter.
Bless.
May please, Lordship. That's it, the matter pertains to regularization, Lordship. And in this case, I have challenged the rejection of my regularization, which is at page 25, Lordship. Annexure K.
Petitioner is aggrieved due to rejection of his prayer for rejection of her prayer for regularization in service system. Heard Mr. H. Talukdar and counsel for the petitioner peruse the amendments made in the petition issue notice returnable in 6 weeks. Since Mr. Who is for whom? Who is appearing for whom?
I have got 3 and 4, Lordship.
Lordship, I am appearing for 1, 5, and 6.
Mr. B. Chaudhary, learned standing counsel PWD, has appeared and accepted notice for respond numbers 1, 5, and 6. Mr. H. Learned SC Finance for respond number 2, and Mr. C.K.S. Borua, learned GSM for respond number 3, service of notices. Completing this course, extra copy of the petition, requisition number, be furnished to the learned Departmental Council, so as to.
May I please, Your Lordship? My Lordship, I'm a casual employee getting minimum pay scale. My grievance is that, my Lordship, I am entitled to other allowances, my Lordship, which has not been paid, my Lord, attached with the minimum pay scale. I'm relying on the judgment, my Lordship, the division bench, my Lordship, page. The parity portion is on page 45, my Lordship.
The writ petitioner hearing is working as a casual employee under the in a subdivision under the executive engineer Kachar bracket W or bracket close division of the water resources department. His grievance is that the respondents have not paid him the other allowances due and payable to him over and above the basic pay. Mr. R.M. Das, Learned SCWR Department, Assam, and Mr. H. Learned SC Finance Department, Assam, has waited for some time to obtain instruction in the matter. NOM 6 weeks since Mr. So-and-so repaired for Mr. Das repaired for phone numbers 1, 3, 4, and 5, and Mr. Chalia for respond number 2. Service of notice is deemed indicated.
May I please, Your Lordship? The petitioner was earlier suspended and later on he was reinstated, Lordship. And white order dated, kindly see page 14, annexure 2. His 3 annual increments was withheld without cumulative effect, Your Lordship.
Where is the order of penalty without cumulative?
Page 14, Lordship. Annexure 2.
So after the 3 years also they are withholding the increment. Increment is being withheld.
Yes, Lordship. And the petitioner is now at the verge of retirement. He asked for that increment releasing, but that was rejected on the ground that with cumulative effect. Lordship, kindly see last page 24.
Yes, Mr. Handy.
Done by the district commissioner. Landed pen can. I'm for respondent one.
We'll issue short notice.
Instruction needed, Lordship.
Lordship. Or Mr. Ashom, Learned Counsel for the petitioner. Here is the amendments made in the writ petition. First up. Pursuant to a departmental proceeding initiated against the petitioner, penalty of withholding of 3 annual increments within courts without cumulative effect, unquote, was imposed upon the petitioner by order dated 27/2/2013. Stop. The grievance of the petitioner is that even after serving the said penalty, the increments due and payable to the petitioner have not been released by considering the penalty to be one within courts with cumulative effect. Stop. According to Mr. Shom, such interpretation of the order of penalty dated 27/2/2023 is wholly illegal and liable to be interfered with by the court. Expressing urgency in the matter, Mr. Shom has further submitted that his client is due for retirement and is facing financial hardship. Therefore, an interim order be passed so as to give relief to the petitioner. Mr. Miss A. Talukdar, Learned GA Assam, appearing for the official.
2, 3, and 4, Lordship.
Numbers 2, 3, and 4 has paid for some time to obtain instruction in the matter. NOM 3 weeks. Give a date of the 3 weeks. Yes. We'll have it on 16th of August. 16th of August. Since Mr. G. Hendik, Learned Standing Council, Revenue Department has appeared and accepted notice for respond number 1 and Ms. Talukdar for respond numbers 2, 3, and 4. Service of notice is deemed to be complete in this case. Extra copies of writ petition, requisite in numbers be furnished to the Learned Departmental Council so as to enable them to obtain instruction. This matter will be listed again on 16/8/2024 as a fixed item. The Learned Departmental Council to obtain instruction facilitating disposal of the writ petition on the returnable date.
Oh,
Yes, Lordship.
Well, this matter is relating to non-payment of pension and other retirement benefit, Lordship. In fact, Lordship, similar issue has already been decided by this honorable court, Lordship. And this case is clearly covered by the judgment, Lordship, page 92.
Page 92.
Page 92 is the judgment and paragraph, Lordship, 19 and 20 is the relevant, Lordship. Page 105.
Is it covered?
My lord, in this case, my lord, department has filed affidavit and it was admitted that they were engaged against
But
sanction.
we examine, we'll take it up for motion next week. Heard Mr. M. Khan, Learned Counsel for the petitioner, peruse the amendments made in the writ petition. The core controversy in this writ petition pertains to the question as to whether, having regard to the date of regularization of service of the petitioners, they would be covered under the old pension scheme or the new pension scheme. According to Mr. Khan, the issue is covered by the judgment and order dated 13/5/2024 rendered by this court in the case of Ranjan Nath, RANJN Ranjan Nath versus State of Assam, third bracket WPC number 1517/2023, third bracket close, and the connected writ petition. First up, Mr. Datta, Learned Standing Council, PNRD. You are for PNRD?
Yes, my lord.
PNRD Department, Assam, however, seeks a week's time to verify the said submission of the petitioner's counsel and address the court. In view of the above, this writ petition be listed again for motion after a week. Mr. CKL Bodwal, Lanet G. Assam, and Mr. D. Bhattacharya, Lanet Standing Council AG. Assam are present. Achha, there is another matter just a little while back. It is this RK Talwar D. Bhattacharya ko diya. You obtained instruction, huh? Kiman number item? Item? কোনটো এটা matter আছে নহয় RK Talwar নাম
My lord, date may be fixed, my lord.
next week, next Wednesday.
Instead of Wednesday, can it be Friday, my lord, or next? Because I have some difficulty on Monday, Tuesday, my lord. I'll not be available.
Thursday.
Thursday, yes, obviously.
Yes.
I'm a family pension holder, Lordship. The government of Assam enhanced the family pension by the office memorandum which is published in 2022. The enhanced rate shall be effective on the 1st July 2022. But my bank, it is Indian Bank, is not really
Family pension means whose family pension?
my wife's.
We'll issue notice of this too. But Mr. Abdul Mazumdar and counsel for the petitioner, peruse the amendments made in the writ petition. The writ petitioner claims himself to be a beneficiary of family pension of his wife, of his deceased wife, full stop, alleging arbitrary non-disbursal of pension in the bank account as per the enhanced rate of DA/DR. The petitioner has approved this court by filing the instant writ petition. Issue notice returnable in 6 weeks, since Mr. Finance Department, Mr. Naik, Mr. P. Naik, Standing Council Finance Department has appeared and accepted notice for respondent number 1. No formal notice is required to be sent to the said respondent. Extra copy of the writ petition will furnish to the Standing Council. Petitioner takes step for service of notice of respondent number 2
One
and
more prayer, Lordship. Considering the age of the petitioner, can it be a little short returnable?
No, you have to serve notice. That's what.
Item 14.
Yeah, please, your lordship. My lord, one of the important document, lordship, that lordship, could not be annexed, lordship, may I pray, lordship, this matter may be taken out on Friday. I'll find one additional affidavit, lordship, bring you a record one inquiry report, lordship. That is important in this case, lordship. That is available in the, but wrongly, lordship.
We'll have it next week.
Monday.
Monday.
Urgency because, lordship, 26 is the date for hearing, lordship, next hearing. In fact, lordship, in this case,
All right, on the request of Mr. M. Khan, counsel for the petitioner, this matter is directly to be listed for motion again on Friday. Friday is
26.
26 July 2020. As a fixed time.
Yes.
Item 15.
Medical officer. Matter is relating to the promotion from grade 2 to grade 3, madam. Idea came before this honorable court, madam. Your lordship, kindly have a look to page 53, madam.
Page
52. Order of this honorable court idea, madam. The order dated 13/3/19. And your lordship will find page 53. When the rule 67 is whether amended rule will be applicable or the idea will be applicable. That is the question involved in that case, madam. So this honorable court directed page 53, my lord. In view of the above, that fourth line, madam, present petitions are disposed of with the direction to the respondent authority to take a decision as to the rules which will be applicable for the consideration of promotion of the parties and inform the parties by issuing speaking order, and thereafter the authority may take necessary steps for promotion accordingly. Next page, the speaking order, your lordship, next page, page 54.
Yes.
In speaking order, it is stated, my lord, the rule, amended rule will be applicable in case of the petitioners. That is the finding, my lord. And they have executive engineer was directed to take steps for promotion in consult with the chief engineer. Nothing has been done. We filed a contempt petition. In the contempt petition, they have stated if as and when vacancy will come, their case will be considered. Vacancies are there, my lord, till today, 8 vacancies are there. One person already retired, one person out of three, my lord, two remains.
Hmm.
So my case, but since vacancies are there, my lord, our case may be considered for promotion. This is the only fair, my lord, in terms of the rules.
Lordship, the appointments are personal. Lordship. Khalasi, can a Khalasi, a person holding a personal post can be promoted to the next cadre post, Lordship. In fact, there are judgments of this honorable court whereby say a person holding a personal post, they are not entitled for promotion, Lordship. This personal post has been created only for them. As soon as they retire or they superannuate, that post goes to your Lordship.
But here, my lord,
Mr. Chaudhary, then they will have to file an affidavit. On oral submission, no order can be passed.
so they are filed, my lord, page 58, it is there, but page 58 of my petition, my lord. In the contempt petition, they have stated, whenever vacancy comes, their case will be considered, my lord. So now they are taking different stand, my lord.
No, maybe, but let them file the affidavit.
Very well, Lordship. Will file.
I heard Mr. H.R. Chaudhary and senior counsel listed by Mr. F. E. Borvi, and counsel appearing for the writ petitioner. Uh, From the basic case projected in the writ petition, it appears that the petitioners are aggrieved due to non-consideration of their case for promotion to the next higher rank. Mr. Chaudhary submits that notwithstanding the speaking order dated 28/3/2019. issued by
As well as contempts in the contempt order
as well
also,
as the
page 57.
assurance given by the authorities before this court as recorded in order dated 1/4/2020
Right.
passed in connection with contempt case number 136/2020.
Page 58 bottom.
The respondents have not initiated any step for promoting the petitioner. Hence this writ petition. Mr. R. Gogoi, Learned Standing Counsel, PH Department, Assam, submits that since the post held by the petitioners is personal to them, hence they are not entitled to any promotion into the cadre posts. The Learned Departmental Council, however, seeks 4 weeks' time to file an affidavit bringing the stand of the department on record. In view of the above, issue notice of motion returnable in 4 weeks since Mr.
You can
Gogoi
accept all, my lord.
All the responding, Lordship.
has appeared and accepted notice for all the respondents, no forming extra.
In the meantime, no promotion, if post is filled up, my lord, our case will come for just one post. Vacancy
Lordship,
are
let the
there.
affidavit come in, Lordship. Because this is a personal post.
Are you going to fill up any promotional post?
That instruction I have to take whether they're gonna, because this is a person,
Promotional post in which rank?
grade 3, your Lordship.
Grade 3, my
Grade
from
3.
grade 4
And they are
to
holding
grade.
a Khalasi, they are Khalasi appointed, they are holding a Khalasi post. And as per the Supreme Court judgment, Dilip Talukdar, personal post, people holding a
No,
personal post.
similar
are not-
case already considered, my
Part of
lord.
the prayer of interim relief having regard to the facts and circumstances of the case. How many petitioners are
Two
there?
petitioners. One already retired in the meantime.
It is,
Oh, three, my lord, three,
it is
sorry.
hereby provided that till the retirement date, the respondents shall keep at least 3 promotional posts in the rank, in the grade 3 categories vacant. Let this matter be listed again on 27th of August 2024 as a fixed date.
Obliged.
Obliged, Lordship.
May I please, your lordship, the dismissal order petitioner was dismissed, lordship, dismissal order 31, page number 31, annexure 8, lordship.
Have you preferred any appeal?
And thereafter I preferred an appeal, lordship, they are sitting over the matter. Lordship, may kindly,
What has happened to the appeal?
Lordship, that instruction I have to take, Lordship, regarding appeal.
No, see, these appeals are becoming meaningless. People have completely lost faith on the departmental authorities.
Lordship.
You are making provision for appeal, not hearing the appeal, not deciding these matters, and these are cases of dismissal.
But Lordship, it's on June only.
Huh?
15th June, yes, preferred Lordship.
no, first,
15th of June, Lordship. Appeal.
no, 1st of July, lordship.
1st of July of last year, no, this year.
This year,
Then what is the problem?
lordship, I am out of service, 6 dependent I have, lordship. That is why if they, dispose of the appeal as expeditiously, that will help me. That is the way, lordship.
Lordship.
At least they.
Friday, you tell us what is the status of the appeal.
Lordship.
No, these appeals have to be disposed of with a speaking order within
Yes,
30
Lordship.
days. That's the order we are going to pass.
Lordship.
Because sending them to appeal doesn't mean we are
Yes.
trying to deny them relief. You'll have to pass order within 30 days. Otherwise, otherwise the order will be interfered
Lordship,
with.
it's on 1st July 27.
Only thing is, it is legally incorrect to allow both proceedings to pursue.
Lordship,
We'll have it on Friday.
Lordship.
So and so for a petitioner on the request of Ms. M. Bhattacharya, learned additional senior government advocate Assam. This matter is directly posted again on 26/7/2024, so as to enable her to obtain instruction as to what action has been taken by the departmental authorities on the appeal preferred by the petitioner.
Lordship. Deeply obliged.
Obliged, your lordship.
May I please, your lordship. In this petition, lordship, we have challenged the order at page 28, whereby I was terminated from service
Order at
without
page,
issuing a page 28, lordship, without issuing a notice to me, lordship.
which department is this?
Lordship, I was engaged as driver in 108 emergency service, lordship, health department.
That's correct, but which department of the government is this?
Health, lordship, health.
Where is the standing council held? Standing council held. Wait for a little while. Hey, Matok, standing council held. Ms. Bhattacharya, can you try and contact the standing council? Who's there? Mr. Baruas, please send a message to standing council health to come here.
May it please your lordship, pursuant to a selection process initiated, lordship, 5 numbers of grade 4 posts were appointed
What is
under the
the matter?
education department.
Find out, we'll have it next Friday.
Lordship,
You tell us for motion. Give him one extra copy.
lordship.
Heard Mr. P. Bordelin and counsel for the petitioner, also heard Mr. R.M. Das, and standing counsel and North Kachar, his autonomous counsel, appearing for the official respondents. Having regard to the facts and circumstances of the case, this court is of the opinion that before issuing notice in the matter, the learned standing counsel must be asked to obtain instruction. Accordingly, this matter is directed to be listed again on 1/8/2024 as a fixed item, so as to enable Mr. Das to obtain written instruction on the basic allegation made in the writ petition. 2 extra copies of the writ petition are furnished to Mr. Das during the course of the day.
Till that the post may be kept in.
No, we'll wait. If they do something, we'll set it aside.
Lordship. Next Friday, lordship. Oblige your lordship. Item 6.
Where is the impugn order page?
Page 28, lordship.
So you were absent for duties for 8 days.
On 4 days, lordship. 1/5/23 to 4/5/23, lordship, 4 days. And for that period, I filed a leave application, lordship may kindly see page 27. Page 27 is my leave application. And it was filed on 30th of April, lordship.
So you are entitled to leave.
Lordship, under peculiar, there is a terms and condition, lordship may kindly see page 19. Even if someone is unauthorizedly absent of 8 days, he should be absent for 8 days to get termination. And I was absent only for
Which term you are referring?
12, lordship. Page 19, column 12, unauthorized absence.
All right, take down. You are appearing for?
I think respondent free your lordship, mission director,
Hmm.
National Health Mission.
Yes, what do you have to say?
Your lordship, here the appointing authority is respondent for your lordship. For GBK EMRI.
It's a private company.
Yes, your lordship. Notice has to put them, your lordship.
So it's a private company.
Lordship, under the government lordship.
Huh?
Under the government lordship.
Everybody is under the government.
Yes,
You are
okay.
also under the government.
Lordship.
But it's a private
Lordship.
employment.
But national justice has to be looked into, lordship. Maybe he is engaged by private company. National justice is everywhere, lordship. That has to be looked
Then
into.
you show me how the writ petition is maintainable against a private company.
Lordship, I am engaged without issue.
We are not interested in whether you are engaged. How a writ petition is maintainable against a private company? You are an employee of a private company, right?
Lordship, private company undertaken by government, lordship.
Undertaken by the government.
Lordship. Government undertaken
Where
company.
is the
Lordship.
undertaking order?
That is not there, but GBK EMRI, lordship may kindly see. My appointment, lordship, page 16, lordship. Appointment.
Issue notice that this, beyond that, not possible. Mr. M.I. Hussain, and counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by the order dated 12/5/2023, passed by the respondent number 4, terminating his contractual services on the ground of absenteeism. Full stop. According to Mr. So-and-so learned counsel for the petitioner, the impugned order, besides being in violation of the principles of natural justice, is also in conflict with clause 12 of the of the terms and conditions of employment of the petitioner, which permits such a recourse only if the employee remains absent for more than 8 days, which is not the present case. Full stop. Since the order assailed has been issued by a private company, that is the respondent number 4, they will have to be heard before passing any order in this case. As such, issue notice of motion returnable in 4 weeks, since Miss
Edas.
who is for 1 and 2?
I can appear your lordship.
Huh?
I can.
Since Miss A. Das,
Yes, sir.
learned standing
On behalf
counsel,
of
Health
B.
and
Gogoi
Family
for
Department
respondent 1 and
person,
2.
has appeared and accepted notice for respondent numbers 1, 2, and 3. And no formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the learned department counsel. Petitioner to take steps for service of notice upon respondent numbers 4 to 7 by registered post with AD within 3 days from today. Hard on the prayer of interim relief. This said prayer will be considered on the returnable date. As an interim measure, it is however provided that the post held by the petitioner shall not be filled up on permanent basis till the returnable date.
Obliged.
This would however not preclude the authorities to make temporary arrangements if so desired. Make stopgap arrangements if so desired.
May please, your lordship, item number 17, madam, they took adjournment without intimating, but the matter may be fixed on Monday because stay is operating from 18. Already our High Court has passed order in similar case, madam. Item number 17, madam, fixed on Monday, madam.
All right, Monday.
Master, yes.
Lordship, so the order is, I think, go in this one.
Lordship, in this case, Lordship, the status report of the Lordship, criminal case, Lordship, wherein Lordship, the charge sheet has been laid by the CM Zillian's case, Lordship, that is pending. That status report was called for. And the learned senior government advocate has been asked to provide the status of the trial, Lordship. This matter was extensively heard, Lordship, and the record was also perused. There was no any such corrigendum, Lordship, wherein Lordship, my name was
by which bench?
Honorable Justice Mehdi. And on the Honorable Justice S.K. Mehdi, and on the last occasion, Lordship, 2 other matters, Lordship, That has also been fixed by this,
Then let it go to the bench, which has heard the matter extensively.
yeah.
Which are the two other matters?
Lots,
Let it
I have
go.
given lots, I have given.
Mr. S.K. Das, Learned Counsel for the petitioner submits that this writ petition has been extensively heard by another bench comprising of Honorable Mr. Justice S.K. Medhi, and the matter was fixed for obtaining further instruction by the Departmental Counsel system. Mr. Das further submits that two other writ petitions being dubbed.
No, that is in different context. I dispute it, my lord.
All right.
That has been asked by the honorable court.
There is only name difference. His name is Nurul Islam Sheikh. My name is Nurul Islam Ahmed. That
Anyway,
is
let it go before the
My lord.
appropriate bench.
only that is the issue. my lord.
Submission made by the petitioner's counsel has not been disputed by the learned counsel appearing for the respondents. In view of the above, registry to take steps for listing this matter before the appropriate bench.
And then
Lots of the other interim order that's been,
Interim order passed earlier to.
and we have urgency, my lord. Even I get the job, my lord, I will be retired in after
Next,
5
next
months.
week, next
Lord.
week.
all right.
Lordship, the petitioners are the members of Marty's family, and they were appointed by the government and under Assam Public Services Preferential Appointment Rules 1999. As per Rule 4 of these rules, they ought to have been appointed on regular basis, but they were appointed on irregular post, and they have been working since their appointment under the respondent number 3. Thereafter, they filed the representation, but thereafter their representation were forwarded to the chief minister, to the PWD secretary. And in turn, the PWD secretary called for a report from the executive engineer, that is respondent number 3. And as per page 31, annexure 10, the executive engineer submitted the report. That there are 17 numbers of section assistant posts lying vacant. Those are regular posts against 25 numbers of regular sanction posts. So that can be accommodated in those posts. It is their prayer.
Where is your appointment order?
Yes.
Who is appearing for the
Annexure
respondent?
1, 2, and 3. Annexure 1,
Who is appearing with the
page
PWD department, lordship. Ardhar is appearing. We have informed him he is coming, lordship.
No, but why the council are not present here?
page
Page
15, 17, and 19 are the appointment letters. And type copy is page 14, 16, and 18. Type copy.
So how many petitioners are there?
3 petitioners.
They appeared in any selection process?
No, Lordship. They were appointed
as because they are the Marty's family, they were appointed under this act. The Assam Public Services Preferential Appointment Rules 1999, Lordship. Rule 4, Lordship.
Rule 4. Yes, so we are disposing of this matter. There is no one for PWD. Yes. Had Mr. A. Sahar, learned counsel.
Maybe the council was on legs, Lordship. He is
I
not.
think A. Sahar, learned counsel for the writ petitioner. Also heard Miss A. Talukdar. Are you appearing in this case?
Sorry, my lord. Actually, my friend was supposed to appear today here, but I was in different, I'm really sorry.
Friend
Got
does
it.
not remain friend anymore, huh?
My lord.
There is a song in Hindi, you know.
Yes, my lord.
What to do. But what is this happening? You appoint people in violation of these rules.
My lord.
After 24 years, they are still struggling for regularization.
My lord, Upendas is coming in, my lord, in between
Huh?
now. Upendas.
Upendas came subsequently.
Yes, my lord. But
Their appointments were in 2000.
2000, my lord.
So you have appointed them in violation of 1993, 1999 rules.
My lord, they were masteral workers, my lord. And now, my lord, we cannot, my lord, after Upendas. That is what my instruction says, my lord. I will file an affidavit, my lord, to the effect, my lord.
But in Upandas, there are other benefits which were given.
That benefits, my lord, they will get. All other benefits they will get, my lord.
You pass an order. Then they'll let them challenge if they're unhappy.
My lord. My lord.
All right. I take down her so my counsel for the writ petitioners. Also heard Mr. R. Dhawl, understanding counsel PWD Assam appearing for the respondent numbers 1, 2, and 3. Full stop. The 3 writ petitioners hearing belong to the family of martyrs of the Assam martyrs killed in the Assam movement on the problem of foreigners and come within the definition of affected candidate under the Assam Public Service bracket Preferential Appointment bracket close rules 1999. Full stop. Section 4 of the rules of 1999 permits preferential treatment to be given to the within courts affected candidates in the matter of public employment. Full stop. Accordingly, the 3 writ petitioners herein were appointed as section assistant under the PWD in the year on 7/8/2000 person whereto they had joined in the said post, full stop. Since then, the petitioners are serving as section assistants under the establishment of Public Works Department, Government of Assam, against uh, against their temporary appointments. The grievance of the petitioners is that despite the lapse of nearly 23 years since their initial appointment, the services of the petitioners have not been regularized till today. Mr. Saad, learned counsel for the petitioner, has submitted that the petitioners have not only submitted various representations, including those in front of those before the highest executive of the state, seeking redressal of their grievance. However, despite running from pillar to post, no action has been taken in the matter, as a result of which the services of the petitioners have not been regularized, despite the lapse of nearly 23 years since their date of initial engagement. The departmental authorities have not filed any affidavit, next paragraph, in this case, but Mr. R. Dhar, learned standing counsel, PWD, has obtained written instruction and produced the same before this court. Full stop. A perusal of the written instruction goes to show that the services of the petitioner could not be regularized due to the decision. Where is it mentioned? Upendas is not mentioned in the section.
My lord, in para one, as per the Honorable High Court's order dated 8/6/2017.
Not be regularized due to the decision of the division bench of this court rendered in the case of Upendas and 836 others versus State of Assam and others. Full stop. Mr. Dhar, however, submits that the petitioners will be entitled to all the benefits as may be permissible within the scope and ambit of the decision rendered by the division bench in the case of Upendas Supra, including minimum of pay scale and other service benefits. If that be so, the respondent authorities must be directed to pass appropriate orders to that effect without any further delay. This writ petition is therefore being disposed of by directing the respondents to pass appropriate orders granting service benefits to the petitioners as may be permissible under the law. The exercise be completed within 90 days from today. After issuance of individual orders in case of each of the three petitioners, if they are still dissatisfied in the matter, we open to the petitioners to approach this court once again in accordance with law if so advised. With the above observation, the writ petition stands disposed of.
May I please, your lordship? My lord, my husband died in harness in the year 2007. I applied for compassionate appointment. The approvals were granted by 2014, my lord. Until 2017, this establishment, they assured me that there is no vacancy, but as and when the vacancy will arise, I will be granted. In 2020, I came to know that some posts were advertised. That means posts were available. And I came before your lordship for that. And now the stand that has been taken by this establishment is that in 2017, that 5% quota rule came in, that was adopted. I do not fall in that. That was abolished and the establishment has adopted the new rule of compassionate family pension, in which I fall in, my lord. If I'm not given the appointment, I can be given that additional benefit of pension money.
So far as compassionate family pension is concerned, that scheme is applicable for the persons who died after 2017. This case falls under the previous scheme.
and her case was considered. And para 12 of the affidavit, we have said that 5% vacancy, there is no vacancy. 5% quota has already been exhausted by virtue of appointment of another person, Manoj Kumar Das.
No, he's
The
saying,
scheme, if I
where is
may
the
please,
scheme? Where is the scheme?
my lord, at page 31,
Page 31.
page 31, the relevant part, I'll please, madam. 5.11. This is the scheme of 2017. The scheme is applicable to those employees who died in harness
1 minute.
on or after 1/4/2017.
Just a minute, I have not found anything in page
Oh,
31.
page, my lord, sorry, my lord, 73, page 73. The scheme starts at page 71. I'll place the relevant portion at page 73, my lord.
The petitioner's husband was an employee in,
SDGM code as process server. And that was later on converted to CGM code. And my case was considered by the CGM
he died in the year 2007.
in 2007. The approval by SLD and all were granted by the finance department also in 2014.
Approval of,
Approval of the finance department and the compassionate this state level
approval for what?
approval for appointment.
Compassionate appointment.
Compassionate.
Then what happened?
In 2014, those were granted. It was sent to the SDGM court. They said the posts are not there at the moment, so we'll consider it as and when the posts are available. It was not granted. In 2017, I approached the Registrar General by an application. He forwarded my application to the CGM court. They convened a board meeting, and in the board meeting, again, it was observed that there is no post available at that point of time, and my appointment on compassion ground would be considered as and when the post will be available. In 2020, I came to know that there were some posts which were being advertised, and therefore I came before you.
All right.
Now, this is scheme, my lord, at page.
But by the
73.
time the compassionate appointment scheme was abolished.
The earlier scheme, the original scheme that I have to go through this district level and state level, that was gone because of a high court decision which says the high court for its employees and its subordinate judiciary employees, they can consider themselves. I need not go there. And thereafter, the new rule of 5% quota came in.
When did it come?
In January 2017. And my consideration by the board of the CGM court was on December 2017. After that scheme came in, that my case should be considered as and when the posts are available. The scheme is at 3rd of January 2017. Scheme is at page 59, my lord, which was later on abolished, my lord. And the board
So today,
resolution.
what is the order you are seeking?
My-
What is the order you are seeking today?
I was seeking.
There can't be compassionate appointment today.
But I was seeking that since he has filed this affidavit and brought on this record on all this, I'm seeking that additional compassionate family pension. I'm getting a family pension, but
Then let you, who is the authority to give it?
the authority is respondent number 1. He has to
Make a representation, we'll ask them to consider and dispose. it
because
within-
I just placed, my lord, page 74, my lord. This is the revised comprehensive guidelines by the pension department. Serial number 1, if your lordship will get. Family pension holders, cases covering death of government employees while in service appointed before 1/2/2005 who are presently enjoying the benefit of family pension from the government of
So
Assam.
has your claim been rejected by any authority?
No,
It
they
is
have not
just
rejected.
inaction.
There is no rejection. And then Roman 1, my lord, the family pension sanctioned to a family of a government servant who died while in service on or before 31/1/2016. So I fall in this. Page 70.
So let the Registrar General pass an order in our application.
No, petitioner can submit a representation, but legal position is that this scheme of compassionate family pension.
Legal, why would you decide? The High Court has not said no to her.
No, here it says this scheme is applicable to those employees who died in harness on or after 1/4/2017.
Prasad, learned counsel for the Preferential. Also heard Mr. H.K. Das, learned standing counsel, Guwahati High Court, appearing for the, you are appearing for all the three.
Yes.
In facts of the case in a nutshell are that the husband of the petitioner, the deceased husband of the petitioner, was serving as a process server under the establishment of SDJM Udalguri,
Udalguri,
bracket now
CGM,
CGM
Udalguri.
Udalguri, bracket close. He died in harness on
3/11/2007.
3/11/2007. Full stop. Since the husband of the petitioner was the sole breadwinner of the family, she had submitted an application seeking appointment on compassionate ground against any grade 4 post. Full stop. The application of the petitioner was processed and was examined by the, where are those documents?
My lord, page 21, if you not see.
Was examined by the judicial branch of the government of Assam, as well as the
Itself, it is there only, first paragraph, third line, and second last line. In the office of the so-and-so, Udalguri has been approved by the state level committee in its meeting on 3/4/2012, and also has an approval of the finance dated 5/12/2012.
was examined by the government of Assam, whereafter the same was approved not only by the judicial department, but also by the SIU, bracket, SIU Finance Department. And an instruction was issued to appoint the petitioner against a grade 4 post in the establishment of Chief Judicial Magistrate Udalguri. However, when the petitioner approached the concerned authority, she was not issued any appointment order on the ground that vacancies were not available. Mr. Prasad submits that the petitioner was assured that she will be appointed as and when a vacancy arises for absorbing her. The vacancy in the grade 4 arises for absorbing her. As the petitioner was awaiting the order of appointment, the scheme for appointment on compassionate ground came to be replaced by the
Page 59.
by the new scheme within course, scheme for appointment, scheme for compassionate family pension in lieu of compassionate appointment, unquote, which was notified by the government of Assam in the official gazette on 14/9/2017. Full stop. After the publication of the new scheme, the earlier scheme of issuing appointments on compassionate ground has been dispensed with and or replaced by compassionate family pension. However, Mr. Prasad submits that in view of clause 5.11 of the OM dated of the notification dated 14/9/2017, the petitioner may not be entitled to compassionate family pension since her husband had died before 31/3/2017, that is coming into effect of the subsequent scheme. According to Mr. Prasad, although there were subsequent advertisements made in the establishment of CGM for appointment in the grade 4 category, the authorities did not issue any appointment order in favor of the petitioner. First up, he further submits that till today, there is no formal communication to the petitioner as to the reasons for not appointing her, despite the approval and recommendation by the competent authority, including the finance department, nor has her prayer been rejected till today. Under the circumstances, the petitioner has been compelled to approach this court by filing the instant writ petition. Stop. Mr. Das, managed SC, GHC, on the other hand, submits that the petitioner would not get any benefit under the compassionate family pension scheme within course, since her husband had died before 31/3/2017. However, whether the petitioner ought to have been appointed under the previous scheme is a matter that may require proper verification. Full stop. After taking note of the submissions advanced at the bar without expressing any opinion. on
My
the
lord, we
merit-
record one submission, my lord.
Right.
The scheme of 2017 says 5.12 at page 73 that the pension so and so department will take further necessary action accordingly by amending, issuing necessary guidelines. And this page 74 guidelines have been issued wherein the time period has been extended, my lord.
Responding to the above, Mr. Prasad is a Mr. Das officer. Mr. Prasad, by referring to the guidelines issued by OM dated 31/10/2017, more particularly clause
Clause 1, Roman 1,
clause 1,
Roman
Roman 1 submits that
on or before 2016. 1 to 2005 to 31/3/2016.
that the time period for application of the new scheme has subsequently been extended by the government, and therefore the petitioner would come within the purview of the compassionate family pension scheme. First up, after hearing the arguments advanced at the bar, without expressing any opinion on the merit of the claims and counterclaims of the parties, I dispose of this writ petition by granting leave to the petitioner to submit a detailed representation before the respondent number 1, making a fresh claim within the ambit of the notifications governing the field. First of all, if such representation is referred by the petitioner within 2 weeks from today, before the respondent number 1, by enclosing a certified copy of this order, the same be examined and considered in accordance with law and be disposed of by a speaking order within a further period of 45 days thereafter. Full stop. In doing so, the respondent number 1 shall bear in mind the peculiar facts and circumstances of the case, as well as the transitional provisions in the two schemes, which have areas which have overlapping periods of operation due to the extension of time frame. Writ petition stands disposed.
All right. Deep.
Item 24.
Okay, Your Lordship, on the last occasion, I was directed to obtain instruction, specific instruction, why the provisional pension was stopped. My instruction is that, my lord, he is getting the provisional pension, my lord, not stopped.
He's getting the provisional pension, but they have not regularized the regular pension.
Regarding regular pension, my lord, need some, my lord, 2 weeks time to file affidavit. Because, my lord, he was earlier appointed as an additional mandal. As an additional mandal for or particular purpose for settlement only in the Dhubri. And thereafter, my lord, he was regular mandal. That's why this period is not regularized. It will take some time, my lord, so 2 weeks time may be granted. I will obtain instruction.
Let him file affidavit. Mr. T.C. Chotil and additional senior government advocate Assam, appearing for the state, has obtained instruction and appraised this court that the petitioner is receiving his provisional pensions, but due to due to the need for regularizing some period of service of the petitioner, his pension could not be regularized till today. The learned government advocate for some therefore prays for 4 weeks time to obtain instruction and to file an affidavit in this case. Mr. J. Henry, Learned Standing Council, Revenue Department, Assam, and Mr. C. Borua, SC, AG Assam are present on behalf of the respondent. Please,
As Bashar.
as Vishal and counsel for the petitioner, submit that she has no objection if 4 weeks time is granted for filing. In view of the above, this matter stands adjourned for 4 weeks. So as to enable the respondents to file affidavit.
Lordship, I'm sorry because he's escaped my notice. Can it be taken up Monday, Lordship? Any date next week, Lordship.
Ms. G. Bapujari, Learned Counsel is present on behalf of the petitioner on the request of Mr. B. Chakravarti, Learned Counsel for the respondents. This matter is directed to be listed again on Wednesday. With the date.
Item 25.
May it please your lordship. For the entire matter considers, concerns to the promotion to the rank of sub-inspector, unarmed branch, the police. The contention is, rest things are okay. Promotion was held, written examination, whatever is okay. But out of 203 vacancies, I'm an STP. They did not give me or many others on the count that the candidates were not there. They had a line to say that, the vacant due to non-availability of reserve category candidate. We said, there was no fixation of.
We'll come to that. Why this matter is, this is for disposal?
Lordship, Lordship, on the last occasion, there was a direction, Lordship, to produce the later dated 25/1/24 on seal cover, Lordship.
What is the letter date 21?
That is a minute, Lordship, where it was decided the cutoff marks were decided, Lordship, that minute.
In fact, they have stated in the affidavit that there's a different system of applying the roster. They say out of 250 marks,
The petitioner belongs to which category?
STP.
Lordship. The cutoff marks are decided 92%.
So they have taken a stand in the affidavit. We go a little bit deep, They have taken a stand in the affidavit in which they say 117 candidates secured 40%. 117 candidates secured 40%, which is 100 marks. And based on that, they fixed the vacancies for others. That perhaps is not according to the rules. Vacancies and application of reservation would be prior in hand. It's not how many
So
candidates.
your client did not get promotion?
No. And one promotion is kept reserved under interim orders because they stand, it belies all logic. There's 117 would get 40%. And we acted on 117 and then we found out the reservation. I said, even that is wrong on principle. And the vacancies you did, that is wrong. So there are vacancies, one person is aggrieved, can be accommodated, no difficulty with that. Others have not come. The way they
All right, this has to be
absolutely
heard on a non-miscellaneous basis. All right, take down heard Mr. S. Bunny, Learned Counsel for the petition, also heard Ms. A. Talukdan, who has produced the minutes of the proceedings of the meeting of the promotional board held on 25/1/2024 in a sealed cover as called for by this court. Upon opening the sealed cover, I perused the proceedings. Mr. Banik has addressed elaborate arguments on the validity of the procedure adopted by the board while fixing the cutoff mark for the general category candidates, which, according to the learned council, had a cascading effect on the reserved category candidates as well. However, upon hearing the arguments advanced at the bar, this court is of the opinion that the matter would call for full-length hearing. As such, issue rule returnable on when do you want it?
Any day in August, member.
Returnable on 20th of August 2023. Since the parties are already represented, all you are appearing for.
Or it can be posted for admission hearing, Milord. Otherwise, it goes for hearing and it's in the end list.
I am for lodging.
Matter will call for detailed hearing. As such, on the request of Mr. Banik, let this matter be listed again on 20th of August 2024 as a fixed item for admission hearing. The minutes of the promotional board dated 25/1/2024 be retained with the record of this case in a seal cover.
Could you be part-time, Milord?
No.
Obliged.
I am for respond number 1
The
to 5
interim
only, Lordship.
And 1 to 5, and who is there? Who else is there?
I think, no, sir.
Interim order passed earlier to continue to the next.
Departmental Examination Board, Lordship.
What about the other respondents?
So Seva would come in, Milord.
And
1 to 5. Who is it?
private respondents also.
You are for?
Chapter of it, Milord.
Huh?
Seva, Lordship.
What is the respondent number?
There were 6. 6 and 7.
What is your name?
J. Bathari, Lordship.
J. Bathari for respondent number 6 and 7. 20th of August.
Obliged.
Admission.
Interim continued, Milord.
Interim order passed earlier to continue till the next day.
Lodge.
May I please, Your Lordship, my lord? Termination of the contractual employee, my lord. Without, on the basis of the inquiry report, my lord. And my lord, I think this matter is covered by your lordship's judgment of Ali Ahmed, my lord.
Is it
Well-
covered?
Will not cover, my lord. My lord, in fact, there are other some requisitions are pending, similar, my lord. Lordship may tag with those matters, my lord.
Which are the requisitions?
WPC number 4707 of 2023.
Take down heard Mr. Swanson and counsel for the petitioner also heard Mr. S. Bhaktan and a standing counsel PNID department Assam who submits that similar requisitions are pending before this court and therefore this matter be also tagged along with WPC number
4707 of
4707 of
2023.
23 and the
Yes.
connected requisitions. In view of the above, registry released this case again along with WPC so and so and so.
Obliged.
My lord, there was a earlier taken time for affidavit, my lord. In the meantime, my lord,
In
affidavit.
the meantime, the respondents may file affidavit bringing their stand on the top.
Obliged.
Item 27.
May I please your lordship? Lordship, today morning we have filed our affidavit and the copy is also served to the petitioner counsel.
Next Monday, my lord.
But the affidavit is not in record, lordship. So
You don't want to file a rejoinder.
But reason is not necessary, but I received a
Alright,
copy, my lord.
I take down heard Mr. A. Kanikar, learned counsel for the petitioner also heard.
NH Sharma
NH Sharma, learned counsel appearing for the
for all the respondents.
respondents who submit that affidavit on behalf of our clients has been filed only this morning by serving advance copy upon the petitioner's counsel. Mr. Kanikar has confirmed receipt of copy of the affidavit, but submits that no rejoinder is required to be filed on behalf of our client. In view of the above, however, the affidavit is not on record. In view of the above, registry to tag the affidavit with the record of this case and list the matter again for admission after 10 days.
Obliged.
Diploma.
Item 28.
So this is relating to my family pension matter. And my respondent number, my 11 has filed an affidavit. Admitting that my process is going on. It's not page 30, my can have a look, my
Family pension has not been released. Why?
According to them, my lord, I have not completed, my lord, more than 10 years in service. But, my lord, I served, my lord, 10 years, 8 years, my lord, and died. Page 30, my lord, and if you my lord, the last part, my lord. Page 30, my last part, my lord.
Yes.
And from bottom, my lord, 8 line, my lord. The Office of the Superintendent of Police Board of Assam has sent WT message dated 15/2024 to the petitioner to report to the Office of the Respondent number 11 to submit relevant documents to process the family pension. Subsequently, the petitioner had reported to the Office of the Superintendent of Police, and the process of her family pension has already been initiated. That is the affidavit filed.
Because the person, he was appointed under certain scheme, lordship, where the mandatory period was 10-year service, lordship. So he expired before 10 years, lordship, 8-year service. So thereafter it was taken up with the authorities, lordship. Then the Deputy Secretary of the Government of as a political B department, lordship, they have said that yes, proportionate pension can be granted, lordship. Accordingly, this has been communicated to the petitioner and he has submitted. So last communication was of 15/3/24, lordship. Thereafter, we have not obtained any instruction, lordship. The updated status is not with us, lordship. Whether this has been granted or not.
Did let matter, he has not been released.
Then what is to be done?
Because the office, AG is also a party. Then lordship may fix it on next week. In the meantime, I'll obtain what is the updated status.
We'll have it next Thursday.
Lordship.
Heard Mr. A. Chronicle and Council is hearing for the writ petitioner. Also heard Ms. M. Bhattacharjee, learned additional senior government advocate Assam, who submits that the department has taken a decision in principle to release proportionate family pension to the petitioner, taking note of the period of service rendered by her deceased husband for 8 years. However, the learned government advocate Assam has sought posting of this matter again on next week Thursday, so as to enable her to obtain updated instruction as to the stage on which the as to the stage of the process initiated by the department for release of family pension. In view of the request made by Ms. Bhattacharjee, this matter stands adjourned till the first of August.
Diplo.
Item 29.
May it please your lordship.
Yes.
My lord, the petitioner before your lordship have been serving more than 16 years, my lord, continuously as a permanent government service holder. And no, my lord, promotion is there. So thereafter, my lord, the department has realized and introduced a scheme, my lord. And as per that scheme, my lord, the persons whoever served more than 8 years would be promoted to the Lance Nayok or my lord, Habildar. So here is a case, my lord. More than 8,000 people have already been promoted under this same scheme. Although, my lord, we have been putting labor for more than 16 years instead of 8 years, but nothing has been done. So notice of motion was issued, my lord, and direction was given to file reply, my lord.
Lordship, reply is ready, lordship. Kindly take it up on next week, lordship. We have called for swearing on Monday, lordship.
Mr. M. H. Chaudhary, Senior Counsel, assisted by Mr. P. Chaudhary, and Counsel for the writ petitioner. Also heard Ms. M. Bhattacharjee, learned additional senior government advocate Assam, appearing for the state, who submits that affidavit on behalf of the department is ready and shall be brought on record within a week from today.
Yes, lordship.
By serving advance copy upon the petitioner's counsel. Considering the nature of controversy involved in this proceeding, an affidavit from the department would be necessary. As such, registry to list this case again after 3 weeks by tagging the affidavit filed by the department with the record of this case. Subject to filing of affidavit within 1 week, the petitioner's counsel may obtain instruction and file rejoinder if specified.
I do. May it please your lordship. My lord, in this case, the
withholding of increment in the salary of the petitioner will be given effect from this month, my lord. So, my lord, if my lord possible, my interim order, my lord, because the entire the disciplinary proceeding which has been drawn is not maintainable in law, my lord. That's why disciplinary procedure has been challenged, my lord, because why the man who has allowed the petitioner to go for foreign trip has initiated the proceeding, my lord. That is your lordship. Can you look into, my lord, the annexure 1? Annexure 1, my lord. He has submitted application to the registrar from his district authority, my lord. Would you subject prayer for seeking permission to visit Thailand for family tour and thus only for so and so? With due respect, I would like to pray before you seeking permission to visit Thailand for family tour and thus want to able only for 15 days, so and so, so and so, so and so. Then, my lord, in the next annexure 3, the leave has been granted. Now, disciplinary proceeding has been drawn. Page 21, my lord.
1 minute, 1 minute. Page 21.
21. That registrar has granted the leave. Sri Santanu Tamili Junior Inspector Auditor Court Society is granted on leave for 15 days with effect from so and so, so and so under so and so. Sri Santanu Tamili would have entered into officiate so and so, so and so, so and so. Subsequently, my lord, now, my lord, the proceeding has been drawn and punishment has been imposed.
Where is the charge from?
Yes, that is the 23 another 5. Charge number 1. While you were serving as junior so and so in the office of the Deputy Registrar Court, Dorong Mongol, you have availed a foreign trip to Bangkok so and so by on leave without prior permission from the government. Now, holding this one, I have been punished. Discipline has drawn and punishment is imposed for holding of 2 increments.
Your permission of the government is required.
No, how he has already granted my permission.
Where is the permission of the government?
The government permission, my lord, actually application he has to be forward, my lord. If the government permission is
the permission for foreign tour?
Yes, in the application it has been written, my lord, that I am going to foreign tour. In the application it is mentioned.
Where is the permission for foreign tour? Permission is for earned leave with headquarters.
That is played in the by annexure 1. I have played that I need 15 days leave for foreign tour, my lord.
Correct, but foreign tour is not been mentioned in the permission.
Permission not yet mentioned, but that is the thing, and he has now drawn that, my lord. So, at least, my lord, so whether it is a man can be a cause of his own person, my lord. He cannot be a cause of, my lord.
Yes.
He cannot be a judge of his own cause, my
Not judge of his. If
No,
you ask
own-
for something not given, means it's not been given.
And even though permission also, in the disciplinary proceeding, when the punishment has been imposed, he has relied upon the preliminary inquiry report, not the inquiry report which is submitted by the inquiry officer.
There, you have gone to Bangkok.
Yes, my lord.
You asked for permission for foreign travel.
Foreign trip to the department.
Right.
And
That
department has to
permission is
forward, actually, my lord, department is to forward that application to the government.
Correct.
But he has granted, my lord, so I did not.
No, where is the permission for foreign trip, foreign travel?
There are only 15 days, my lord. Though he has not,
Mr.
though he has
Sinha,
not meant.
How long you want to argue, then I'll pass the order.
No, my lord, I cannot do it. Let them file affidavit, my lord. And it will be disposed of, my.
Not received the instruction. Kindly 2 weeks.
You are
meeting.
appearing for whom?
I'm appearing on behalf of Corporation Department for all the respondents.
He is not the, register is not the government.
My lord, I being an employee, I do not know that they are.
Doesn't matter. You do not know means you have to face the consequences.
My lord.
Yes. Everybody will say, I do not know. When you are in government service, you want to visit abroad. Even let me tell you this, even as judges, when we go, we have to get the approval. If you don't know, you will have to face the consequences.
And my lord, here
Absolutely.
In the, my lord, the memorandum, the registrar has to forward the application to the
Fine.
government.
If he has not done it, proceed against him. But you cannot go and come back and say that he should have done. There are our judicial officers sometimes don't get permission.
I have been granted leave, my lord.
All right, heard Mr. B. Sinha, counsel.
My lord, let them file affidavit, my lord.
B. Bania.
B. Bania, Learned Standing Council, appearing for the Learned Standing Council Cooperation Department, Assam, who prays for another 4 weeks' time to file affidavit responding to the allegations made in the writ petition. In view of the above request made by the department counsel, let this matter be listed again after 4 weeks. In the meantime, counter affidavit, if any, on behalf of the department be brought on record.
If you dispose of that, my lord, whatever,
An attempt to be made to dispose of. the
dispose of that
litigation.
matter.
So
Obliged.
it is what, reduction of three,
Two
reduction,
increments,
two
my lord.
increments.
Two increments.
That's a minor penalty.
Minor penalty.
He is violated, nothing can be done. If you did not get the permission, he did not get the permission.
Obliged.
Yes.
May I please, your lordship? Lordship, the matter herein is that the respondent authorities floated an advertisement. I was eligible, I applied. I went through all the examination, written examination, followed by skill test. I qualified everything. Now I applied under the person with benchmark disability, under the category. And now the protocol is that I'll have to go through a medical test that will be conducted by a board, which is constituted by the respondent authorities. I went through that medical test, and therein, in the result, it was declared that I am not a person of benchmark disability. I was aggrieved. I made representation before the department. Then, along with me, there were also other applicants who were aggrieved. So when all the applications were received, then the respondent authority decided that we will do one more medical test. So one more medical test was done. Even in that list, the final list that came, my name was not there. So I was aggrieved. I made representation. There was no reply. I moved to this honorable court. Then your lordship passed an order with directing them to provide me with a disability status. What is my disability status? What is the outcome of the medical board report? And it was provided to me. And therein it reflects that my disability is only 23%. It is far below the benchmark disability. So I am aggrieved that that is wrong. I am assailing that finding of the medical board, which says that my disability is 23%. Now, after the result that was declared was on 19th of August 2023. After that, I went to Guwahati Medical College Hospital. It is the same place where my medical test was performed by the board. And during when I did the test again, my disability percentage came to be 57.1%. That is above the benchmark disability mark. So hence, I have approached before this honorable court because assailing that my disability is 23%, your lordship.
In that case, lordship, if after re-verification his percentage has come to 57, lordship, I'll like to file an affidavit, lordship. Because herein.
But what about the posts?
The post, lordship, it is the social justice and welfare. Public. Which is the department? In this matter. Personal department is also a party, lordship. Because, lordship, we have only conducted the medical re-verification, lordship. So, lordship.
Lordship, in item 33, we need to obtain instruction, lordship. It was first more than 3/6, and now they have served the extra copies, lordship. So we require another 4 weeks time, lordship. And similar other cases are posted on 16/8 also.
Yes, your lordship. Similar means they're also challenging the same remark sheet of the board.
You are Mr.
I'm Mr. A. Khan.
And lordship, there is one writ appeal also listed today. It was dismissed by a coordinate bench of this honorable court, lordship, so they have preferred an appeal. It is listed today.
Mr. A. Khan, learned counsel appearing for the writ petitioner, who submits that although the petitioner's disability level was initially assessed at 23%.
23%.
Yet on re-verification of the same by a competent board, it was found to be 57%, which is above the benchmark disability. Therefore, the petitioner is assailing the decision of the authorities to deny him appointment in the post of?
In the post of Junior Inspector, Auditor of Cooperative Societies.
Junior Inspector stroke Auditor of
And
Cooperative.
there's one more post, your lordship, Assistant Block Development Officer in the Rural and Panchayat Development.
Assistant Block Development Officer under the Assistant Block Development Officer in the against the quota reserved for persons with disability.
This benchmark disability.
Benchmark disability. Stop. Mr. D. Upamanu, Learned Standing Council, Health Department, Assam, and Ms. M. Bhattacharjee, learned government advocate Assam, have both paid for some more time to file affidavit by submitting that similar matters were fixed before this court on 16/8/2024. Mr. C. Sharma,
For 7, 8 and 9.
learned counsel for the respondent number 7, 8 and 9, and Mr. For for respondent numbers, R.B. Goswami for respondent numbers 10 and 11 have also made a similar request. In view of the above, registry released this case again on 16/8/2024, along with others similar matters which are fixed on that day. In the meantime, the respondents may file affidavit.
This is regarding non-release of retirement benefits, madam. Now, retirement benefit, in the meantime, affidavit has been filed. Lords will take up page number 33. They have admitted, they say they have still to pay 12,40,160 rupees. And this person is retired on 30/11/2019.
So why they have not paid?
And they say now we are going to pay it in installment. There are some financial
Can
plans.
it be installment?
Also, yes, because of acute financial condition of the board, Lordship. Similar matter, we are complying this Honorable High Court. Lots of matter more about more than 50 matters, similar matters already complying, we are already complied. And per month, we are going to pay Lordship more than 1 crore rupees in the name of retirement benefits, Lordship. As because of since long ago, the retirement benefits are pending by very much employee, Lordship, who are retired already.
What to do?
And
My lord, Lordship will there are
Other
similar.
similar orders have been passed.
Yes, yes, my lord. Page number 19, my lord, my petition. With interest, within, yes, given 7% interest, my lord. Within 12 equal installment, they have to pay. Lordship will turn to page number 19 onwards. There are 2 orders, my lord.
So has this order been complied with 24/4/2024?
Yes, my lord, they are paying, my lord.
Huh?
Lordship.
Why a similar order should not be? What has happened to order dated 24/4/2024? Have you complied with it?
Yes, my information is that they have said they are paying it and they will pay a 7% interest.
We are already complying it, Lordship.
Paragraph 5 will make it clear.
More than 50 similar
Yes,
matters
20.
we are complying, Lordship.
So a similar order will pass in this case also? Lordship. Right, heard Mr. S. Bora, learned counsel for the petitioner. Also heard Mr.
T.R. Gogoi,
T.R.
Lordship.
Gogoi, learned counsel appearing for the respondents. Mr. The writ petitioner here is a retired employee who had served the Assam State Housing Board, Guwahati. The petitioner retired from service on 30/11/2019 as assistant engineer, zonal housing office, Dibrugarh. Pursuant to his retirement, the petitioner claims to be entitled to how much he was entitled to?
No, Lordship will turn to page number 9, madam. I have given the counting, my lord, this entire calculation. My claim was 14,70,160, but they say I am entitled to 12,40,000. I will
3,70,160.
I will take that up.
However, according to the ASHB, the petitioner is entitled to an amount of rupees
12,40,160 rupees.
12,40,150.
60 rupees.
60 only.
Lords.
As retirement benefit. Mr. Bora submits that his client is willing to accept the determination made by the board to the above effect. However, a direction ought to be issued by this court to release the amount since non-payment of the retirement benefit is posing serious difficulty for his client. First up, responding to the above submission, Mr. Gogoi, Leonard ASHB submits that the board is not averse to paying the retirement benefit to the petitioner and the other similarly situated retired employees. However, since there are a large number of claims and there is resource crunch, and also considering the fact that similar orders have been passed by this court in a number of cases which are being implemented simultaneously, Mr. Gogoi has prayed for an order permitting the board to make payment of the retirement benefit to the petitioners on installment basis. After going through the materials on record, it appears that this court has already passed orders granting liberty to the board to make payment of retirement dues on installment, subject however to the payment of interest at the rate of 7% annum on reducing balance. On 24/4/2024, this court had passed an order in the case of a similarly situated retired employee of the board, namely retired employee of the board in the case of Anima Bharali versus Assam State Housing Board and two others, third bracket WPC 765/2024, permitting installment payment of retirement dues after taking note of the submissions made by learned counsel for both the sides. First off, the observations made in para 5 and 6 of the said order are relevant for the purpose of this case. 5, 6, and 7 are relevant for the purpose of this case and are therefore reproduced herein below. Since learned counsel for page 21 and 22, since learned counsel for both the sides are in agreement that a similar order can be passed in the present case as well, I dispose of this writ petition by providing that the first installment of rupees, how much?
Lordship, equal installment, my lord, it will be divided by 12. It will come to an end on July, today July, my lord, June 2025.
Admitted retirement dues of the petitioner shall be
Equal installment.
paid in
What?
in 12 equal
12
installments
equal instrument.
commencing from
This month itself, my lord. It will come, end up in June, June 2025.
First week from August, Lordship.
commencing from 1st of August 2024.
Lordship.
The
Every succeeding month, in first week of the every
with
succeeding.
one installment in every succeeding month till disbursal of the entire amount. Interest at the rate of 7% per annum on reducing balance will be applicable on the unpaid dues. However, if the respondents fail to comply with this payment schedule, then this could say over and above, then in that event, over and above other legal consequences, the board may also be liable to pay enhanced rate of interest on the unpaid amount. With the above observation, this writ petition shall be disposed.
Only another pair, my lord. Only thing is that this person is from Gulaga. He cannot come in every day and I will provide the account number. They will pay on the account number itself.
Lordship. The consequences there before that, the amount payable to the petitioner shall be deposited in his bank account, the particulars of which will be furnished by him with competent authority on or before 30th of July 2024.
Lords.
Item 37.
We have filed our affidavit in opposition yesterday on
That has not come on record. They file an affidavit.
You have received copy.
I have received. Yesterday I have received.
You want to file rejoinder? How much time?
2 weeks.
Mr. BK Singh, Learned Counsel for the respondent submits that counter affidavit on behalf of his clients has been filed yesterday, but the same is not on record. Mr. D. Talukdar, Learned Counsel for the petitioner, has prayed for 2 weeks' time to obtain instruction and file rejoinder. In view of the above, registry to list the matter again after 3 weeks by taking the counter affidavit stroke rejoinder affidavit, if any, with the record of this case.
Obliged, ma'am.
After the order of suspension, they have not extended within a period of 90 days. This is on the face of the record. Your lordship sees, my lord, page 34. This is the first order of suspension. And on page 45, your lordship sees, my lord, it is after 169 days they have done it.
So he was placed under suspension on
26/10/23. Then extension was not done within the period of 90 days as per provision of law. Then page 45, your lordship will get 18/3/23, my lord. It is the 24, it is extension order after a period of 169 days. This itself is in violation of provision of law, as your lordship has held in judgment. Detailed judgment is there. 2019 1 GLT 804.
But we have obtained our instructions, my lord. I pray for 10 days time. I will file our affidavit in the meantime. My lord.
No, but what affidavit? It's all legal issue.
But what we contain is, my lord, he was released from jail on 30/12/23, my lord. And we contend that the period of review of 90 days will come from that date, my lord.
30/12?
30/12/23, my lord. That is the order of the bail, my lord, in POXO case.
So he was arrested in a POXO case.
POXO case, man.
Child labor at home. Both his wife and his petitioner, my lord, was arrested in connection with POSCO case, child labor.
But as on date, my lord, disciplinary
And
proceeding
wife
has
is
been initiated, my lord.
reinstated. Wife is also a lecturer, my lord. She has been reinstated. And this is a legal issue, as your lordship has rightly said, my lord. This is.
But then we'll give them 10 days time because.
They should produce the records, my lord. Because
Mr. B.D. Gas, senior counsel, listed by Mr.
D1000,
counsel for the petitioner. Also heard Mr.
D. Kolita, my lord.
D. Kolita, learned standing counsel, APGCL, Assam, as well as Mr. Sikhi, learned. Government of Assam appearing to the Department of Mr. Kalita, 10 days time to file counter affidavit responding to the allegations made in the writ petition. Prayer allowed. Let this matter be listed again after 2 weeks. In the meantime, counter affidavit on behalf of the department.
Obliged.
You are also appearing in this case.
I have 41. Can you get a date, madam?
Oh, everybody wants a date. 20th of August.
Obliged.
20.
May I pray, Lordship? Lordship, I am praying for 2 weeks' time to file my affidavit, Lordship. I am appearing for Karbiang Autonomous Council.
There is a stay order. Heard Mr. Muni, learned counsel for the petitioner. Also heard Mr.
R.S. Ronghang.
R.S. Ronghang, learned counsel appearing for the
KAC, Lord. Karbiang.
KAC. Oh, praise for and is granted 2 weeks further time to obtain instruction and file affidavit. Let the matter be listed again after 4 weeks. Interim order passed earlier to continue.
May it please, your lordship. My lord, while I was serving as Mundal, my lord, I was arrested in connection with the Prevention of Corruption Act, my lord. Thereafter, I was arrested, and subsequent thereto, I was placed under suspension, my lord, under Rule 6(2) on 5/4/2023. That order, lordship will find at page 28. A suspension order, my lord.
What is the issue today? What is to be done? Disposal.
Yes, my lord, they have filed an interlegal application praying for vacation of the stay order, my lord. In that application, they have stated that they can furnish me the inquiry report, and with the order under challenge, my lord, it may be cancelled, my lord. This is the stand at paragraph 5, my lord. If lordship take up the IA number 1871. Page 5 of that IA, paragraph 5.
Where is the order, first of all? Which page is the order?
My lord.
Orders ought to be vacated.
Lordship will find at page 11 of the IA. Operative portion is page 12.
The next page, Lordship.
So something is missing in between, huh? You correct this, IA.
No, Lordship.
You take this. Page 11, 12.
Order was, yes, ma'am.
Lordship. Lordship.
You look at the court file.
Lordship, the first part of the order is missing, Lordship.
Rectified then. How much time will you need?
Lordship, how much time, Lordship? I can provide a.
My lord will find that order at 27/9/2023. In the main file, lordship will find that order. The order dated 27/9/2023.
So what is the impugn order 22/9/2000?
Yes, my lord. That lordship will find at page number 41 of the writ petition. The DP was held, my lord. I participated. Thereafter, this order was issued, my lord. Page 41.
And where is the report of the inquiry officer?
That lordship will find at page number. Page 13 of the IA, my lord. Inquiry report was never furnished to me, my lord. From this IA, I can lay my hands on it, my lord. Page 13.
Lordship, as per my instruction, Lordship, it was furnished, Lordship, but through regular post.
But you participated in the inquiry procedure.
Yes, I participated, my lord.
So they will furnish you inquiry report and then proceed.
Their stand is that they have sent it through regular post, my lord, but no material has been brought to the record, my lord. And after filing of this IA, I came to learn about this report. And lordship kindly peruse the paragraph 5 of the
So
IA.
what is the relief you want now?
My lord, today, my lord, my prayer is, my lord, to set aside this order, my lord, impugn a writ petition, and I may kindly be reinstated, my lord. Because from
Lordship,
2023, my lord, my order has not been reviewed, but my lord, they have filed an additional affidavit on 11/6/2024. The reason cited for not reviewing is oversight, my lord. Additional affidavit, lordship will find it page 43.
Have you received the inquiry report now?
After filing of this IA, my lord, I come to know about the inquiry report.
Correct. So
Yes.
now you have got it.
Yes, my lord.
So what do you have got to say?
My lord, I'll file the reply against the inquiry report, and the proceeding may go on, my lord. And in the
They have
meantime,
issued they found the charge to be proved. It's a corruption charge.
is a corruption charge.
Then they want to dismiss you from service. And you want the court to reinstate you.
My lord, I was suspended on 25/4/2023, and the reason cited, my lord, and the review order was passed on, my lord, on 21/5/2024, after a gap of more than 1 year, my lord. The period of 90 days has already been gone. No review order, no.
That's correct. See, these are not like machine. Review order, 90 days, these are in some context. Here is a person against whom an inquiry has been held, he has been found to be guilty. They want to dismiss you from service. And you say that, all right, till you do it, reinstate me. That order, why should we pass
My
that?
lord, the inquiry report has been submitted, my lord, but the disciplinary authority has yet to pass an order, and I have, before that, I have to file a reply.
disciplinary, the final order was there, Lordship. That was only an intimation of the final order to the petitioner, Lordship. And that they have annexed as an impugn order, and they took the interim order, Lordship. And for that interim order, the
So you have
proceeding
been
is still,
dismissed from service.
Lordship.
And my lord, the impugn order at page 41, it has been issued under the rule 18 of the fundamental rules, my lord, FRSI. And rule 18 relates to, my lord, if an
Oh,
employee,
forget it, Mr. Just tell me one thing very clearly.
my lord,
Your client has been dismissed by this order 22/9/2022. Is it not correct?
no, my lord, this
You
order,
are hereby informed that so and so, so and so, so and so.
you are here informed that under rule 9 of subsidy rule, so why the penalty is prescribed under rule 7(7), my lord. I have been asked to so cause within a period of three days, my lord, as to why I should not
So
be.
you have received the inquiry report now?
I have just received the inquiry report.
When?
After filing the IA.
And they have replied also, Lordship.
All right, within 7 days you file your reply, then we'll see. Mr.
Reply they have filed, Lordship.
Yes, fine.
And against the inquiry report, no reply has been filed, my lord. We have filed reply against the IA.
Lordship.
Against the inquiry report, my lord, no reply has been filed, my lord.
See, what is the problem is, we know these technicalities, legalities, you are not going to get a reinstatement from this court. Once it is established that you are guilty of corruption, you can't hide behind technicalities. Technicalities of law is always going to be there, but this is to be used in situations which demands it. On one hand, there are inquiries, proceedings, you have apologized, you have admitted that you are guilty of wrongdoing. And on the other hand, we'll shut our eyes to everything and say that, no, just because 90 days it has not been done. That kind of orders this court will not pass. You argue, we'll lay down the law if necessary. This is not the circumstances when by default of the authorities, somebody is made to suffer. Then the courts will spring in and say that, all right, if you have not reviewed, that means you are not serious about the matter. So reinstate him. Why should he suffer? But here is a case where in the meantime, the matter is proceeded. You have admitted, I have seen, you apologize for your conduct. It's a corruption. So in a corruption matter, what apologizing? This is a case. Corruption means serious action will follow. What leniency you expect from the court, Mr.? Please tell us.
My lord, in that case, my lord, as per the contents on paragraph 5 of the IA, I may be allowed time to file a reply against the inquiry report, and my lord, they will take decision on it.
Is it a matter of right? Do you have any right to file a reply against the inquiry report?
As per rule 9A, my lord.
No,
Of the
Lordship.
64 rules.
No, Lordship.
Kindly produce, my lord, rule 9A.
Lordship, this is a matter when the person is become guilty and he was convicted with the high penalty, Lordship. This is severe penalty, Lordship. And in this, Lordship,
All right,
he should
we'll
not
take
get.
it up at 2.
Right.
Come at 2. We'll continue at two. Okay.
My lord.
Hmm. So there was a disciplinary proceeding initiated against the petitioner.
Yes.
Where is the DP? Where is the charge memo?
Yes, ma'am. At page 32, my lord, of the writ petition. Page 34, lordship will find the charges, my lord. It has been put on record that you were caught red-handed by the team from the Director of Vigilance and Anti-Corruption Assam on 28/3/2023, while you were accepting bride amount to rupees 3,000 only from one Sri Mehboob Hussain Borbuya, son of late Kutubuddin Borbuya. So in Assam, and the bribe money was recovered from your position in presence of independent witnesses by the team from Vigilance and Anti-Corruption.
Right.
Thereafter, the statement of allegations are there, my lord. At page 37, I have filed my reply to the so-called notice denying the charges, my lord. If lordship peruse the third paragraph from the bottom, my lord, at page 37, may I read, my lord? That, sir, I was forcefully given the amount of rupees 3,000 by Sri Mehboob Ali Borhuya, complainant of the case, with an intent to trap me in by ACB personnel behind the net. And same, my lord, I have repeated at page 38. Paragraph number 6, my lord, from the top. After submission of this reply, my lord, I have submitted an application before the Deputy Commissioner as I was not paid my subsistence allowance, my lord, at page 39. Lordship will find that
So
later.
what is the prayer in the writ petition?
Prayer in the writ petition is, my lord, for setting aside that order. Lordship will find at page 17, the 22/9/2023. And my lord, I have also paid for reinstatement, my lord. Prayer F.
So are these judgments and decisions you are relying upon, are those cases where during suspension period, DP was drawn and the person has been found to be guilty, charges proved, and the authorities are contemplating major penalty? Are those cases also on those facts like the present one?
My lord, I want to rely upon a judgment, my lord, of division bench. That State of Assam versus Ojit Sonwal. It was reported in the SSC, Supreme Court. In this case also, my lord, at paragraph 3 is the fact, my lord. It is a judgment.
That's all right. You are addressing the author of the judgment.
Yes.
Then which part of the judgment helps you?
Paragraph 13. From careful, paragraph 13, my lord. From careful analysis of the above decisions of the Supreme Court, what follows is that unless review is held within 90 days, an order of suspension, including one issued due to the detention of an employee in custody for 48 hours, would not survive, nor can such an order be granted fresh lease of life by carrying out a review after expiry of the period of 90 days. In view of the law laid down in the case of Deepak Mali and Ajoy Kumar Chaudhary, it is axiomatic that the order of suspension dated 7/12/2019 had lapsed after expiry of 90 days due to want of review of the same by the disciplinary authority. We therefore find ourselves in agreement with the findings recorded by the learned single judge. And my lord, regarding that letter at admission to guilt, my lord, I've made a categorical statement at paragraph 10, why I have to submit that letter, my lord. Paragraph 10 of my writ petition at page 9.
Which letter?
This, my lord, that admission of guilt, my lord. Annexure H, page 40. Paragraph 10 may kindly be perused, my lord. That as no action is forthcoming from the respondents towards payment of subsistence allowance and reinstatement of petitioner in his service, the family of the petitioner has been compelled to live in penury and starvation. The petitioner, being left with no other option, had written a letter to the additional deputy commissioner Katsar by tendering his apology for the charges imposed upon him, and further requested to exonerate the petitioner from the charges leveled against him and to reinstate the petitioner in his service. And if Lordship peruses the impugn order at page 41, this letter has no indication that it was issued in terms of my apology letter. And my lord, page 41.
And he was placed under suspension by which order?
By 5/4/2023, Lordship will find it page 28. Page 28 is the order. Whereas a report has been received from the settlement officer Katsar and Hailakandi district, Silsar, right, so and so dated regarding arrest of Mohammed Misbah-uddin Lokkar, Patwari of this establishment now working under the disposal of settlement officer Katsar and Hailakandi district, Silsar, for third resettlement operation by the team of Vigilance and Anti-Corruption Assam in connection with CBPS case number so and so, my lord. Whereas there are sufficient grounds that reflect negligence and unlawful activities, considering the above facts. And as per sub-rule 2 of the rule 6 of the rules of 1964, Mohammed Misbah-uddin Lokkar is hereby placed under suspension pending departmental proceeding. It was deemed suspension, my lord, since I was arrested.
All right.
And my lord, page 41 letter, my lord, which is impugned in the present writ petition.
Yes.
It was issued in continuation of the so-called notice dated 20/05/2023. My lord will find a reference. And it was issued, my lord, under Rule 18 of the FRSR.
So there was a departmental proceeding conducted,
Yes, my lord.
or was it by invoking the provision of Article 311?
311.
Dispensing,
Yes, my lord.
you are saying yes to both.
The departmental.
Was a departmental inquiry conducted?
Yes, my lord. Departmental inquiry is conducted.
And inquiry report is there.
Inquiry report is there.
Where is the inquiry report?
It is in the IA, my lord.
Yes, page number.
13. And the suggestion is at page 14. Down below it. Suggestions in view of the above facts and as because of the official is caught red-handed while accepting bribe by the Vigilance and Anti-Corruption team, a trusted and reputed government agency for dealing with corruption-related cases. As such, the matter is crystal clear that the activity of Mohammed so-and-so has largely maligned the reputation of the establishment under District Commissioner Katsar in order to build a...
So your client has participated in the inquiry proceeding?
Yes, madam, I participated.
And now he has also received the inquiry report.
After filing this IA, my lord, I received this.
But is there any necessity to give him an opportunity to represent against the inquiry?
As per Rule 9A of the rules of 1964, my lord. May I read, my lord? Communication of orders. Orders made by the disciplinary authority shall be communicated to the government servant, who shall also be supplied with a copy of the report of the inquiry, if any, held by the disciplinary authority, and a copy of its finding on its charge, or where the disciplinary authority is not the inquiring authority. A copy of the report of inquiring authority and a statement of findings of the disciplinary authority together with brief reasons for its disagreements, if any, with the findings of the inquiring authority, unless they have already been supplied to him. And also a copy of the advice, if any, given by the commission, and where the disciplinary authority has not accepted the advice of the commission, a brief statement of the reasons for such non-acceptance. So as per this rule, my lord, I am entitled for a copy of the inquiry.
All right.
And if lordship permits me, I beg to place reliance on a judgment rendered by the Honorable Supreme Court, my lord, in Muhammad Ramzan case, my lord, Ramzan Khan case. It was reported in 1991, 1 SCC 588. I beg to refer paragraph 18.
Paragraph?
Paragraph 18, lordship will find at page 597.
Yes.
We make it clear that wherever there has been an inquiry officer and he has furnished a report to the disciplinary authority at the conclusion of the inquiry holding the delinquent guilty of all or any of the charges with proposal for any particular punishment or not, the delinquent is entitled to a copy of such report and will also be entitled to make a representation against it if he so desires. And non-furnishing of a report would amount to violation of rules of natural justice and make the final order liable to be challenged thereafter.
All right. All right. So we'll ask we'll give him 7 days time to make a representation. And the deputy commissioner will consider this and pass a appropriate order. Nothing beyond that. No reinstatement. We are not. Reinstatement is not allowed. Okay, take the heard Mr. R.M. Dekal, counsel appearing for the petitioner. Also heard Miss A. Talukdar, learned government advocate Assam.
For respond number 3.
For the respond number. Let's see really the Mr. J. Henry Learned
3 and 4, Lordship.
Revenue Department, Government of Assam appearing for the respond numbers 1 and 2, and Miss A. Talukdar, learned G. Assam appearing for the respond numbers 3 and 4. This writ petition has been instituted inter alia assailing the order dated 22/9/2023 issued by the District Commissioner, that is the respond number 3. District Commissioner Kachar, that is the respond number 3, herein proposing to impose major penalty of dismissal from service upon the writ petitioner. Full stop. The facts of the case, in a nutshell, are that the writ petitioner, while serving as a patwari in the establishment of settlement, patwari or Latmandal?
Latmandal at Silsor Sadar Circle, my lord.
In the amount of that, Kasar Malot, it is said Malot, Patwari.
It's called Patwari, Lordship.
And the high faculty, it is Amin.
Patwari bracket Latmandal in the office of subdivisional officer. Is the SDO's
Assistant Settlement Officer, my lord.
assistant settlement officer Kachar was caught red-handed while accepting bribe for an amount of rupees 3,000. Thereafter, Anti-Corruption Bureau case being ACB PS case number 22/2023 was registered under section 7 bracket small a bracket close of the Prevention of Corruption Act 1988 on the basis of an ejahar filed by the complainant, namely Sri Mehboob Hussain Borbhuya. Stop. The petitioner was arrested in connection with SCB PS case number 22/2023. When was he arrested?
28/3/2023.
28 on 28/3/2023. Thereafter, by order dated
25/5/2023.
5/4/2023, the petitioner was placed under suspension due to his arrest and detention in prison, in the prison by invoking the powers under Rule 6 bracket 2 of the Assam Service bracket Disciplinary and Appeal bracket close rules from 1964 ako bracket dibo for hereinafter referred to as the rules of 1964 bracket close. Full stop. He was released on bail later on.
Yes, my lord, later on released on bail.
Later on, the petitioner was released on bail by order dated 25/5/2023, passed by the learned special judge Assam in connection with SAB PS case number 22/2023. Full stop. Following that, a disciplinary proceeding was initiated against the petitioner. And he was, and the petitioner, and by the communication dated, what is the date? 28th May 2023, is it? Charge memo, page 33.
23/5/2023, my lord.
And on 23/5/2023, memorandum of charge along with the statement of allegations was served upon the petitioner. Stop. The petitioner had participated in the departmental proceeding initiated by the authorities by appointing inquiry officer who had submitted the inquiry report dated
25/8/2023, my lord.
25/8/2023, holding that the charge brought against the petitioner has been established. Accordingly, established in the departmental proceeding. Accordingly, it was suggested that the punishment of dismissal from service be imposed upon the petitioner. Following the same, the impugned order dated 22/9/2023 was served upon the petitioner, asking him to show cause as to why the penalty of dismissal from service along with disqualification for future employment should not be inflicted upon him. Full stop. It was at that stage that the petitioner had approached this court by filing the instant writ petition by assailing the order dated 22/9/2023. Full stop. It is also the submission of petitioner's counsel that the order dated 5/4/2023, by means of which the petitioner was placed under suspension, has not been reviewed before the expiry of 90 days, as is required under several judicial pronouncements on the subject. Full stop. Therefore, the order of suspension has lapsed by operation of law, and hence the petitioner is liable to be reinstated in service. Full stop. In support of his above argument, Mr. Deka has relied upon decision of the division bench of this court rendered in the case of State of Assam, represented by the Commissioner and Secretary and another, versus Ajit Sonwal and others, reported in 2023 SCC Online GAU 731, to submit that due to failure on the part of the respondents to review the order of suspension, the same has automatically lapsed, and therefore the consequential benefits ought to be given to the petitioner. Full stop. Next, Mr. Deka has further argued that his client was never served with a copy of the inquiry report dated, the date to circulate wasn't dated so and so. Full stop. It was only during the pendency of this proceeding that the respondent number 3 has filed an IA, being IA bracket C bracket close number 1871 of 2024 with a prayer to vacate the interim order dated 27/9/2023 passed in this writ petition, wherein the copy of the enquiry report has been enclosed. First up, it is only from such enclosure that the petitioner for the first time came to know about the enquiry report. However, however, according to Mr. Deka, his client is entitled to make, is not only entitled to receive a copy of the enquiry, however, Mr. Deka submits that the petitioner was not only entitled to receive a copy of the enquiry report, but under Rule 9A of the rules of 1964, he was also entitled under the law to make a representation before the authority against the findings of the inquiry officer, as well as the proposed penalty, which opportunity has not been granted to the petitioner. First up, relying upon the decision of the Supreme Court rendered in the case of Union of India versus Mohammad Ramjan Khan, reported in 1991 bracket close 1 SCC 588. Mr. Deka has argued that denial of opportunity to the delinquent to submit representation against the enquiry report would amount to violation of principles of natural justice. First up, the learned counsel for the petitioner has therefore submitted that an order be passed by this court reinstating his client in service and also by granting him an opportunity to submit a representation against the enquiry report before the concerned authorities. Opposing the above submissions, Ms. A. Talukdar, learned counsel for the state, has argued that the petitioner has already been found to be guilty by the enquiry officer. First up, that apart, he was caught red-handed while accepting bribe of rupees 3,000, and subsequently the petitioner had also submitted a letter addressed to the additional deputy commissioner, Kachar, admitting his guilt. Under the circumstances, no procedural violation can be said to have been made. Now, under the circumstances, it cannot be said that there is any procedural violation in this case leading to the enquiry, leading to the furnishing of the report of the enquiry officer. Stop. Similar is the argument of Mr. Hendik, Learned Standing Counsel, Revenue Department, Assam. Stop. Before adverting to the facts of this case, before recording any finding on the submissions made at the bar, it would be pertinent to note herein that by order dated 27/9/2023, the learned single judge had suspended the operation of the order dated 22/9/2023 as an interim measure. First up, as a result of the said order, no penalty could be imposed no penalty as proposed by the departmental authorities could be imposed upon the petitioner on the basis of the enquiry report dated so and so. Situated thus, the respondents have approached this court by filing IA bracket C bracket close 1871 of 2023 with a prayer to vacate the interim order dated 22/9/2023. It is to be noted herein that the materials available on record clearly suggests that the writ petitioner was caught red-handed by the Officials of the Anti-Corruption Bureau of Assam while accepting bribe of rupees 3,000 from the complainant Mehboob Hussain Laskar. Full stop. Thereafter, proceedings were initiated thereafter.
Mehboob Hussain
criminal
Bormiya.
proce- huh?
Mehboob Hussain Bormiya election.
Mehboob Hussain Bormiya. Thereafter, ACB PS case number so and so was registered against the petitioner and he was arrested to be released subsequently on bail. The petitioner was also placed under suspension due to his arrest and detention in prison beyond the specified period. Full stop. Subsequently, an inquiry and subsequently a departmental proceeding was held against the petitioner in which we had participated. There is no plea in this proceeding that the petitioner was not afforded sufficient opportunity to protect his interest during the departmental proceeding. Full stop. The inquiry officer had submitted a report before the respond number 3, wherein it has been specifically held that the charge brought against the petitioner has been proved. Full stop. It is in the aforesaid factual backdrop that the respond number 3 had issued the impugn order dated 22/9/2023, asking the petitioner to show cause as to why major penalty of dismissal from service with disqualification of future employment could not be imposed upon him. Full stop. The learned departmental counsel has stated that the inquiry report was sent to the petitioner by post. However, Mr. Decca has denied receipt of such inquiry report and has maintained his stand that the petitioner became aware of the inquiry report only during the pendency of this writ proceeding. Full stop. On a reading of Rule 9A of the rules of 1964, I find that there is a provision under which the order of the disciplinary authority is required to be communicated to the government servant and is also a government servant along with a copy of the report of the inquiry officer. Full stop. In this case, there is a dispute as to whether the copy of the inquiry report was received by the petitioner. Full stop. Be that as it may, as on date, there is no doubt or dispute about the fact that the writ petitioner is in receipt of a copy of the inquiry report, which is enclosed as annexure in IA Civil 1871 of 2024. First of all. Therefore, there can be no impediment on the part of this court to grant reasonable time to the petitioner to make his representation before the respond number 3 against the inquiry report, if so advised. Full stop. In the case of Mohammed Ramjan Khan Supra, the Supreme Court has made the following observations. Para 18 to quote করব। That was also a case where a disciplinary inquiry was contemplated under Article 311 bracket 2 of the Constitution. Wherein an inquiry report was submitted against the delinquent. Full stop. By taking note of this position, which emerged after the 42nd Amendment of the Constitution, dispensing with the requirement of furnishing copy of the inquiry report upon the delinquent, the Supreme Court has held that notwithstanding such amendment, the delinquent will still be entitled to represent against the conclusion of the inquiry officer, holding that the charges or some of the charges had been established against the delinquent. Full stop. By applying the ratio of the decision rendered in the case of Muhammad Ramzan Khan, bracket Supra, this court is of the unhesitant opinion that the petitioner is entitled to one opportunity to submit a representation against the inquiry report dated so and so, ventilating his grievance in the matter. First up. Insofar as the prayer of the petitioner to direct his reinstatement in service pending issuance of final order of penalty, I am afraid such a prayer of the petitioner cannot be accepted by this court. Full stop. In the present case, as noticed above, the petitioner was not only caught red-handed while accepting bribe, but the charge brought against him has also been established in an inquiry proceeding conducted by following the due process of law. Full stop. As a matter of fact, the authorities are contemplating to impose the maximum penalty of dismissal from service upon the petitioner. Full stop. Therefore, merely because there has been some procedural lapses on the part of the authorities in furnishing the inquiry report to the petitioner by following the process, therefore, even assuming that there is some lapse on the part of the authorities to furnish the copy of the inquiry report upon the to the petitioner in accordance with law, that cannot be a valid ground for this court to ignore the fact that the petitioner, charge of corruption brought against the petitioner has been established in a proceeding conducted in accordance with law. The decision relied upon Mr. Dekka in the case of Ajit Sanwal and others Supra did not contemplate a situation where the delinquent was found to be guilty in respect of serious charge of corruption / bribery in an inquiry proceeding conducted in accordance with law. Therefore, I am of the opinion that the ratio in the case of Ajit Sanwal and others, Supra, would have no relevance in the facts and circumstances of the present case. In the light of discussions made herein above, this writ petition is disposed of by permitting 10 days time with effect from today to the petitioner to submit a representation before the respondent number 3, ventilating his grievances, if any, against the inquiry report dated so and so and the findings recorded therein. Upon receipt of such representation, the petitioner shall also indicate as to whether he desires any personal hearing by the respondent number 3, and if so, the petitioner be given an opportunity of personal hearing in the matter. Upon completion of the aforesaid process, it would be open for the respondent number 3 and or disciplinary authority to pass any further order in the matter, including an order imposing penalty upon the petitioner. Penalty upon the petitioner in accordance with law. If the petitioner continues to remain aggrieved in the matter, it will be open for him to avail legal remedy as may be permissible under the law. With the above observation, the writ petition is disposed of. Consequently, the IA stands closed. So IA petition.
My lord, in terms of the interim order, I am getting the subsistence allowance, my lord. You may kindly be continued till the final order pass, my lord, since I am under
No, that we
suspension.
are not saying anything.
Lordship, the order dated 27/9, Lordship, that goes, Lordship.
Huh?
The stay, Lordship.
Look, that you ask your seniors what happens. When the court passes an order, it merges.
Lordship.
Things that you don't know, you ask your seniors.
Lordship.
Don't ask the judge.
Lordship.
Both these,
Deeply obliged, Lordship.
both the proceedings stand dispute. It will merge in the earlier order.
Lordship.
That's the law.
Lordship.
Yes.
Deeply obliged.
Deeply obliged.
This is regarding non-payment of some area salary with effect from 1/4/2023 to till date.
Non-payment of area salary.
Yes, ma'am.
Which department is this?
It is social welfare department.
Yes, who is appearing? Social welfare.
Social welfare.
Lordship, in this matter, we have received instruction, Lordship, and the affidavit is unwaiting.
What is your instruction?
Lordship, it says, Lordship. May I read, Lordship? But an intimation in connection with the release of her current monthly honorarium, including that of her area payment, was also forwarded by the former CDPO so-and-so, ICDC project, by letter and so-and-so, Lordship, notwithstanding the fact that the matter relating to the shifting of her present AWC other to the other place, and the issue is already under subsidized by WPC so-and-so, and the answering respondent was still considering her matter with regard to the release of her pending area salaries, including that of the current monthly salary honorarium.
So why are you not paying her? You are telling the court that because the matter is sub judice, no action is taken.
Lordship,
What kind of a
it's
standing?
subsequent development, Lordship. It's a subsequent development, Lordship, and now
No, Ms. Talukdar, he has come to the court saying that I am not getting my salary.
Lordship.
You one time you want to file an affidavit and tell the court that because it is sub judice, we are not paying salary. What kind of a stand is this? Why are you not paying the salary?
Lordship, the matter of paying her salary and the pending salary also, it's under consideration now, Lordship.
What is there to consider? Why you have stopped it in the first place?
Lordship, that was due to the transfer of that Anganwadi center, Lordship, without any official order.
Well, you file your affidavit. Heard Mr. M. Mondal, learned counsel for the petitioner. Also heard Ms. A. Talukdar, learned government advocate Assam, appearing for the respondent numbers 1 to 4 and 6, who submits that she has received instructions and therefore be permitted 3 weeks time to file affidavit. Mr. You are for?
Respondent number 5, Lordship.
Mr. B. Chakravarti, learned counsel is present for respondent number 5, and Mr.
Next.
Respondent number 5.
I am
On
for
the request of
3, 4, and 6, Lordship.
On the request of Mr. Talukdar, this matter is adjourned for 4 weeks, so as to enable her to file affidavit. You file it.
Lordship.
Agor case to you, Agor case is a line it for you. Order, then again. After living in person, hearing a person, plus fresh orders, dealing with the grievances of the petitioner. Statement, as well as imposition of penalty based on the inquiry report dated first, as may be deemed necessary under the law. आपने जाओ बेटे change करो.
56 is also not identical issue.
Time मिला no.
56 same non-payment of salary with effect from 1/4/2023 to till date.
Just for order, it is lordship stoppage of the monthly honorarium lordship.
what with the instruction we have received, lordship, this honorarium, lordship, when does certain no order was issued pertaining to the honorarium held up of the petitioner, the answering respondent was contemplating releasing her area pension, including the current honorarium, and seeking budgetary requirements subsequently from the directorate. This is from the CDPL, lordship. After the lordship, this intimation has been sent, but another intimation in regard to release of a monthly honorarium was sent to the CDPO to the ADC, lordship. And but no conclusive instruction pertaining to the release of our monthly salary is received till yet. So lordship, we have to receive some kind of instruction from the DC also, because this has been sent to the ADC.
All right, now Mr. M. Mondal, Learned Counsel for the petitioner. The matter pertains to grievance on account of non-payment of monthly salary stroke honorarium to the petitioner. Mr. CKS Borwa, Learned Government, Assam, appearing for report numbers 1 to 4 and 6. Praise for 4 weeks further time to obtain instruction in the matter. You're therefore,
Accountant.
that is the respond number.
5.
Mr. D. Bhattacharya, Learned Counsel, is present for the respond number 5. None has appeared for respond number 7. On the request of the Learned G. Assam, this matter stands adjourned for 4 weeks, so as to enable the offering instruction.
Most of us.
Obviously.
Item 42.
Lordship, in this case, senior advocate Mr. S. Dattal, along with his juniors, is a Lordship. Their name is, I talked to him that their name may be shown, let it come after 2 weeks, Lordship. Showing the name of.
This matter be listed again after 2 weeks by showing the name of Mr. S. Dattal and senior.
For the bank, Lordship.
Appearing in the bank along with his junior in the cause list.
Item 43.
Yes.
There is a contempt petition, my lord. There is direction to pay the promotional family pension to the petitioner, my lord.
Notice has been served.
Notice has been served, my. In the meantime, my lord, they have paid some amount to the petitioner. They have paid the amount with effect from, my lord, 1/5/2019. And mother died on, my lord, 17/10/2018. From 17/10/2018 to 30th of April 2019, that period they have not paid. Other amount they have paid now.
Look, what is this? They are writing letters to the registry in contempt matters. We are directing personal appearance of this officer. He is writing letters directly to the registry in contempt matters.
Promotional family pension.
Heard Mr. I.S. Sekal and his counsel appearing for the contempt petition. None has appeared for the respondents. Office note indicates that notices have been issued to respond numbers 1 to 6 by registered post with AD. However, no answer notice has been returned back from the respond numbers 1 to 5. I also find from the materials on record that the Under Secretary to the Government of Assam, Public Health Engineering Department, namely Sri Champuk Deka, has received notice in connection with the contempt case, but instead of appearing in the matter to counsel, he has directly addressed a letter to the registered contempt from a Guwahati High Court. in the letter dated so and so, there is also no mention as to whether the order of the court has been complied with. This court has time and again pointed out that addressing letters to the registry in contempt cases, in connection with contempt cases by the officers is not only impermissible under the law, but the same is also in clear violation of the government circulars holding the field. Under the circumstances, this court is left with no option but to direct personal appearance of the officer concerned first to answer the queries of this court in the matter. As such, Sri C. Decker, Under Secretary to the Government of Assam Public Health Engineering Department, is directed to remain personally present before this court on the next date fixed. Registry to communicate this order to the concerned officer through special messenger. Fix this case, list this case again on 16th of August 2024.
Item 44.
Next review, Lordship. The review has been filed for a review of the common judgment, Your Lordship, and Lordship has already disposed of the similar matter by this judgment, Your Lordship, and this is also covered by this judgment, Your Lordship. May I praise the judgment?
Heard Miss R.M. Miss
R.
R.
Dekal.
Dekal and counsel appearing to the review petitioner. His review petition is preferred against the common judgment and order dated 27/9/2022, passed by this court in WPC number 7370/2021 and the batch of connected writ petitions. It appears that similar review petitions against the order dated 27/9/2022 passed by this court were earlier dealt with and disposed of by this court by order dated 12/6/2024. Passed in review petition number 77/2024, whereby this court had declined to interfere in the matter or to recall the order dated 27/9/2022 for the reasons stated therein. Ms. Dekka has fairly submitted that this case is also covered by the order dated 12/6/2024. In view of the above, his review petition is held to be divided in a merit. The same is accordingly.
Item 45.
May I please your lordship kindly see office note dated 31/5. Respondent number 3 has already appeared. As for
Well-
respondent number 1 and 2, I may be allowed to take fresh steps.
My lord, I'm also appearing for two also, man. I can appear, man.
How many total? 3 respondents? are
Three
there?
Yes, one already retired, my lord.
You are appearing for 1 and
2
2.
and 3, my lord.
2 and 3. So what has happened? The order of the court has not been complied with.
My lord complied, my lord, in fact, 2 times as in place before SLC, my lord. And thereafter state has decided to file appeal, my lord. And numbers of, it's a series of cases, my lord.
Which is the order?
Okay. Page number 115.
This is 31/2023. But that series of appeals are pending. before
Yes,
the
ma'am.
bench. I heard Miss
K. Burman.
K. Vermal and counsel for the petitioner. Also heard Mr. S. Guptal and counsel appearing to respond numbers
2 and 3.
3, who submits that several appeals preferred against the common judgment in order dated 31, 2023 are pending before the division bench. Several appeals preferred by the state against the common judgment in order dated so and so preferred in WPC number 1646/2021 and the batch of connected petitions are pending before the division bench. And therefore, this matter be adjourned till the final decision is rendered in the writ appeals. So, the prayer made by Mr. Datta appears to be just and reasonable and therefore stands accepted. Awaiting the decisions in the writ appeals preferred by the state, this matter stands adjourned for 8 weeks.
Please, your lordship. Lordship, due to illness, my senior is not present. Therefore, I am paying for
It
accommodation.
may be given, lordship.
Your senior is for whom?
For the respondent, lordship, senior, Mr. J.K. Goswami, lordship.
R. Dr. Lord.
Ms. R. Dr. Learned Counsel is present for the petitioner on the request of Learned Counsel for the respondent. This matter stands adjourned for 2 weeks so as to give him one final opportunity to obtain instruction in the matter as to the steps taken for compliance of the court's order. List the case accordingly.
Item 47.
May I be before worship? My lord, kindly see office note, my lord, 22/7/24, my lord.
Who is appearing in this case? Any name? Sorry?
Notice issue. Notice issue.
You take down, heard Mr. N.K. Muri, Learned Counsel for the petitioner. It appears that
Notice of
upon service of notice, the respond numbers 4 and 5 have entered appearance in this case. However, the name of Learned Counsel for the said respondents is not reflected in the cause list.
My lord,
Huh?
just one thing, my lord. Respondent number 4, 5, and 2 already received a notice, and 2 has filed, 2 also filed affidavit in opposition. My lord, I'm just concerning, my lord, respondent number 3, my lord, kindly see the note, addressee left. That is what I'm, my lord, it's Chief Engineer PWD Chanmari, my lord. That is something unclear to me, my lord.
The notice is not served on respond number 3.
3, addressee left.
Hmm.
So, my lord, so far that part and respondent number 1 and 6. That may, I will take fresh step for 1 and 6.
Okay.
And
You can
3,
look,
my lord,
1 and 3 first steps, you take it.
1 and 6.
1 and 6.
Because 3 is remarks, kindly see. Addressee left.
Notice has been served upon respond numbers 2, 4, and 5. So it also appears that the respond number 2 has entered appearance and also filed affidavit in this case. However, the name of the Learned Counsel for the respond number 2 is not shown in the call list today. Registry to therefore verify and list this matter by reflecting the name of Learned Counsel for the respondent in the cause list. On the request of Mr. More, leave is granted to the petitioner to take first steps for service of notice upon respond numbers 1 and
6.
1 and 6.
My lord, 3 what to do, my lord.
1, 3, and 6.
And 3.
You come to my chamber in the evening, I'll tell you what to do.
My lord.
1, 3, and 6.
I am obliged, my lord.
You are asking the court what to do.
Still, office is functioning, my lord.
All right. You ask some senior, they'll tell you.
Still, office is functioning, my lord. That's what I'm obliged, my lord.
Lordship, in this writ petition, I was filed on 6/6/24.
What is the IA about?
But for the correction of the respondent number, name of the respondent number 13,
What is the IA number?
I number 2108. But Lordship, I have not taken any step by mistake. So
You
kindly
filed IA number 2108 of 2000.
24.
Mr. So your name, please?
O Ullah. O Ullah, Oliullah.
Oh, Ullah Council. IA number ISC number 2108 of 2024. Arising out of the writ petition has not been listed today. Register to therefore verify and list this writ petition along with the IA with appropriate office number.
Item 49.
As per office number 28, service report is still awaited, Lordship, as per 28-6.
I am appearing for respondent number 10, my lord. Sufia Begum.
Then
Service
Lordship,
report is awaited on how many respondents?
and then if he's appearing, then 7 and 8 and 9 is awaited, Lordship.
I'm appearing for the health department. Health
No,
department.
you tell me the respondent's name, health department, who are the respondents? And you?
10, my lord, respondent number 10. Private respondent number.
You are Mr.
NZ Chaudhary.
NZ Chaudhary, and council is present for the petitioner. Ms. A. Talukdar, for respondent numbers 3 and 7. What is your name, madam?
IDAS on behalf of the Upamanna.
Ms. Aidas for respondent numbers.
Four,
And Mr.
five,
Your name, please?
6.
S.A.B. Khabir, my lord.
S.A.
B. Khabir.
Bir Khabir. For
Lordship.
respondent number 10. And you don't know who you are representing?
Lordship, I'm appearing for respondent number 1, 4, 5, and 6.
So your name, Aidas?
IDAS.
Ms. Aidas is present for respondent number 1, 4, 5, and 6. Register to verify service of notice upon the remaining respondents and list the matter with appropriate office number after 4 weeks. Yes.
Lordship, there was an interim directive, Lordship, kindly, that may be continued.
Interim order, if any, shall continue to the next date.
Much obliged.
May I please your lordship? The lordship may peruse or office note dated, your lordship 23/7/2024. Your lordship, notice upon respondent number 4 by registered post with AD has been received. But however, your lordship, there has no been signature. But a photocopy of the track consignment report shows that the item has been delivered to in respect of respondent number 4.
All right, you're Mr.
D.S.
Yes,
Dekha.
Dekal and counsel for the petitioner is present. Peruse the office note dated 23/7/2024. Let this matter be posted before the Lodgima court so as to verify if service of notice on respondent number 4 in this case can be deemed to be complete.
Lordship,
Let
I'm
the
also
matter be listed again with the findings of the Lodgima court.
Your lordship, I'm making a prayer, your lordship. Your lordship, let the state respondents file their affidavit, your
In the
lordship.
meantime, the official respondents may bring their stand on record by filing affidavit.
Much obliged, your lordship.
For hearing item 50.
This matter will argue by Mr. Ayush Saika. He is on another courting legs, my lord. After something.
You want time?
Yes, sir. After some time.
No, then we'll have it some other day. What is this matter about?
My lord, this is basically embezzlement of money. He was a process server. He took money for execution of a decree from some litigant. And my lord, thereafter the litigants filed a complaint before the Munshi, and Munshi forwarded it to the district judge. And district judge conducted an inquiry. My lord, evidence were recorded. All the procedures were followed, and thereafter, my lord, penalty of reduction in rank was imposed. He was reduced to the rank of peon, my lord, from process server. That is basically the case. No procedural infirmity, my lord, all opportunities were given. He got the opportunity of
He's
crossing.
still serving as peon.
He is serving as peon.
All right, a prayer for adjournment has been made in this case on the ground that the arguing counsel, Mr. I.H. Saika, is busy in another court. Mr. H.K. Decker, Lanet, H.K. Das, Lanet, standing counsel, GHC is present, along with Mr. C.K.S. Bhova, Lanet, G.A. Assam, for the state. However, on the request of the petitioner's counsel, hearing of these matters stands adjourned for
next week.
2 weeks.
Next
2 weeks.
Next week.
2 weeks, 2 weeks. Next matter, please.
May please your lordship, I'm praying for matter to be fixed on next week, lordship, because it is a miscellaneous day and Mr. King Chaudhary, Mr. he is arguing in a different court, your lordship, in a part of matter.
The next week will not be possible.
Then lordship, date,
On the prayer of learned counsel for the petitioner made the consent of the other side. This case again on
some urgencies there, lordship, because my promotion will be held by and I will be ineligible if I am not considered in this year, lordship, for next IS promotion, lordship.
22nd of August, 2028 as a fixed item for hearing.
Much obliged, lordship.
22nd of August.